Lordship, I have permitted to mention one matter for extension of interim order, Lordship. The interim order is expiring on 31st of August, Lordship.
Pension on Friday.
My lord, last occasion, my lord, direction to file this police report by this learned additional advocate.
Lordship, I appear for the Union of India. I'm led by Mr. Dheeraj Kumar Trivedi.
Where is the
Lordship, I'm paying for a short accommodation.
today's accommodation or he is coming?
He's legs before another court, Your Lordship.
Where is the report?
And my lord,
I'm appealing for the NTM.
Miss Pandey,
I'm appealing for the
Amrita
national
Pandey.
testing.
Lordship, I seek a short passover if the matter could be taken up later this week.
11:45 after
Grateful, Your Lordship.
11:45
That I am state mallet on the last occasion also.
none appears on behalf of the petitioner, nor any accommodation has been sought for. On the last day, that is last occasion, that is 18th August 2026, the petitioner failed to appear. In view of the above, the application being CAN 1 of 2023 stands dismissed for default. The writ was dismissed.
Yes. Was dismissed on 8th February 2020.
CAN dismiss for default. So the connected applications কতটা দেবেন না? কত দেবেন?
The time for the applicant.
Hmm.
My lord, restoration application along with section 5. My lord, delay as indicated. My lord, in CAN 2. CAN 2 is 558 days. But actually, my lord, there is a wrong calculation. I have made the calculation and I found there is a 355 days.
355.
350. According to me, 355 days, as because, my lord, the order passed on 17 July 2025. And application filed on 6th August 2026. 383 days and 30 days will be deducted, then my lord 355 days.
Okay.
My lord, it is a similar matter where your lordship A category matters are disposed of by usual terms and conditions, single petitioner before your lordship. My lord, my prayer before your lordship, my lord can allow the restoration and fix a date, it can be disposed of in terms of the your lordship similar order.
There is a specific ground for delay. Take a file and have a
Well, kindly consider CAN 1. The grounds is taken in CAN 1. It says
restoration
application. The section 5.
Section 5.
He still is.
Maybe he mentioned on a 558.
It is true, my lord, it is not been happily drafted. It is true. But I leave it to your lordship. But I indicated paragraph number 2 and 3, but that should not be sufficiently explained.
This is of 2017-19.
My lord, 2017-19, and single petitioner before your lordship.
Where is your certificate?
My lord.
So, Bhattacharya, you have checked the certificate. Pass.
Continuation. Page 50, my lord.
My lord, page 50.
Right, here is the mark.
51, my lord. 51, sorry.
No, আমার কাছে 50. 50.
Certificate. Certificate is
Can 2 of 2026
আমার কোনো বলার নেই।
along with no, can 1 of 2026 and can 2 of 2026. These are the applications seeking for restoration of the writ petition upon condonation of delay. The writ petition was dismissed for default on 17 July 2025. Mr. Gaurav Das, learned advocate for the petitioner, submits that the petitioner, on the date the matter was called on, missed the list. And thereafter, he did not have any knowledge of the dismissal of the writ petition till the first week of January 2026. Upon getting such knowledge, the petitioner filed application for restoration of the writ petition along with an application seeking for condonation of delay of
558 days, it was
550
indicated, but
558 days.
originally
Delay.
355.
354.
55.
55. Yes. He seek for condonation of delay. Sorry, he seeks for restoration of writ petition upon condonation of delay. Mr. Pinaki Bhattacharya, learned advocate. Where is the affidavit of service?
My lord, I do not find.
Oh. You have not served.
But I have served. My learned friend is appearing, but I do not have in my set, my lord, affidavit of service.
Find the affidavit of service tomorrow.
Fine.
On Thursday, not today. On Thursday.
At my apology.
It is there in your brief, or your junior is
No.
carrying that. If you can file that, we'll dispose of this.
Rarely I have seen my junior. That is a difficulty.
On Thursday. Thursday, the application reading, not today. একটু দিন তো একবার রেকর্ডটা একবার দিন না আগের দিনে ফাইল করেছিল দেখি
বলবো কমপ্লায়েন্স পুরো করেছে
ঠিক আছে
আমার ব্যাপারে
কোডটা দিন
লিগ্যাল প্রসেস কমপ্লিট হয়ে গেছে Lord, I am for the petition, Lord.
Balaram for the Pradhan.
And this is a contempt application, and they have already served a compliance report, but it has been revealed from the compliance report that the construction is illegal and unauthorized.
No,
But Lord, your lordship already given a direction that when the construction is illegal and unauthorized, how that will be demolished, your lordship has given a direction. But as per your direction,
that has not been forwarded. Where is the order?
not considered.
Where is the copy of the order?
My lord, I'm led by the advocate on record appearing for the Pradhan, my lord. Learned advocate met with a minor accident yesterday and sustained injuries. I'm praying for simply not to do, my lord.
In which paragraph they have stated that the construction is illegal? In
Yes,
which
my lord.
paragraph?
They have confessed that it's illegal. Yeah, unauthorized construction. Kindly see, my lord, page 15, page 15, 16 and 17. My lord, the official report. And they have given a letter to BDO Joynagar as well as SDO Baraipur regarding this.
Then it's all right. Let the SDO take the decision. They will dispose of the application. It has been complied with. Now the subdivisional officer is to act in accordance with section 23.
But one thing is, Lordship, kindly go through your Lordship's order that your Lordship, here, my lord, the order itself, my lord, the cause of action, my lord. Yeah, your Lordship's order, there is a page 7 in this compliance report. The respondent number 7, Pradhan of Moida Gram Panchayat is directed to consider and dispose of the representation of the petitioner dated 17th July 2023 by adopting the following procedure. So,
What do you want?
well, actually, my lord, by
send back-
invoking section 23,
We send it
when
back for
the
hearing.
construction is illegal.
Illegal, they have forwarded it to the
My
SDO.
lord,
Now
as
the
per
SDO will take the
instructions,
steps.
complied, my lord.
Oh, so SDO will take a step, but
Exactly, my lord.
Affidavit of compliance. On perusal of the affidavit of compliance, it is found that the alleged contemner has found that the construction in question is illegal. The matter has been referred to the subdivisional officer Baripur subdivision for information and taking necessary action. In view of such compliance, the contempt application being WPCRC of 107 of 2026 stands disposed of. The appearance of the alleged personal appearance of the alleged contemner is dispensed with, disposed of. The rule discharge. Foreclosure. Colony as per 23. In terms of section 23 of the Panchayat Act 1970. Disposed of.
Grateful, lordship.
Next.
My lord, I am for the petitioner. Your lordship on last occasion directed me to serve notice upon the contemner opposite
What
party.
is CAN 1? What is CAN 1?
CAN 1 filed by the private respondent for modification. They have not placed this matter as yet, my lord. And what happened, my lord? I have served upon the contemner, but affidavit service is ready, but yet to affirm, my lord. If your lordship grant me some time, I can file the same.
Accommodation is sought for on behalf of the petitioner applicant for filing affidavit of service.
My lord, I can file today. It is ready, my lord. It is ready. It is ready, but only for I can file it in court.
I cannot then on Thursday, not today, on Thursday. Thursday.
No, I'm for the petitioner. The second time, my lord, your lordship kindly consider your lordship's last order date at 11th August.
Medication is yet to be conducted. Yes.
My lord, till date, my lord, even yesterday night, my lord, I have not received, my client has not received a letter from the council.
My lord, the direction was that the respondent number 4 shall be at liberty to seek medical examination of the petitioner if so required prior to the consideration of the representation. And communication has been already made to the CMOH to seek the medical examination of the petitioner, your lordship. That has not yet been received, and further reminder has also been given, your lordship.
What has not been received?
The medical examination report of the petitioner. Kindly, lordship, see paragraph 9 of the improved order. That is the instruction, and those two, these instruction, your lordship, I received today morning.
But this was also, my lord, yesterday, my lord, the last occasion they placed.
This I received
My lord, my lord,
morning only the soft copy. That's why I do not have the original, my lord. If your lordship seeks the original, then on the returnable date I can produce the original. Reminder has also been given on 7th of August. That letter I also have, my lord, soft copy, unfortunately.
my lord, kindly your lordship see the.
Sir, what steps were taken up to 11th August?
My lord, when the order was passed in January, subsequently.
After 11th August, what steps did you take?
Up to 11th August.
After 11th August.
After. My lord, I am still awaiting the medical examination report from the CMOH. That
Sir,
is
in paragraph number 5, alleged contemner is directed to take up the matter of medical examination of applicant with concerned CMOH for doing the needful expeditiously. The alleged contemner is also directed to serve a copy of this order to CMOH MR Bangur Hospital, Kolkata for necessary compliance.
Yes.
Now, where is that compliance?
My lord, on 4th of June 2026.
Sir, on 11th August, we have heard that you have taken steps from your end, but the examination is still wanting. Now, liberty was granted to you to serve the copy of this order so that expeditiously the medical examination petitioner could be done by the CMOH. Now, what steps after 11th August you have taken?
My lord, after 11th August, that I need to take some further instruction, your lordship. The last, I have the 7th
What
August
instruction?
2026 reminder to the CMOH. The instruction that I have received on this date is the medical examinationer's report has.
You have not taken any steps after 11th August.
That I need to take some instructions, your lordship. That I am not aware of. That I need to take some instruction. But a reminder has been given already, even before 11th August, seeking for this report. Until date, it has not been received by the CMOH.
You are for chairman?
Yes, DPSC chairman.
CMOH will be represented by the state?
By the state, your lordship, my lord,
Yes,
just once, my lord, before, my lord, just once, my lord. My lord, your lordship, kindly come to, my lord, page 11 of the, my lord, the order in contempt. My lord, your lordship, my lord, very, my lord, specific order. It was liberty to the, my lord, the respondent, the chairman, to seek for medical. My lord, apart from that, my lord, I have completed, my lord, more than 10 years of service. Medical ground, my lord, is one. The other is one, my lord, distance ground. My lord, these, my lord, understand, my lord, he is not, my lord, the chairman is not, my lord, the pursuing the authority for medical examination. But the other point, my lord, he is not applying his mind. My lord, I even maybe, my lord, transfer on the ground of distance. My lord, I am entitled under the law. But that has not been considered.
The transfer has been sought for in both the grounds, the distance as well as the medical ground. Now, at the contempt stage, he cannot say that now, since the medical examination report is awaited, now I'm only pressing it for distance ground. He cannot say that, the petitioner.
My lord,
So
my learned friend has not understood the, my lord, order probably.
When will the medical examination be completed?
My lord, I'm appearing for the DPSC chairman. If your lordship directs, I can make a further representation upon the CMOH in a week time, that if my lord kindly direct to CMOH to complete it and file a report within a week, that I can communicate. I'm not in the authority to direct the CMOH to do it in a week.
Sir, you have been authorized by this court by the order that the CMOH should take it up expeditiously. Now, by dint of that order, you have not exercised your authority. You have not communicated the order of this court.
My lord, kindly frame it within 7 or 8 days. I will communicate.
Passing it over, get the instruction or ask the chairman to appear. Person. Passing it over. What steps he has taken after 11th August, get that instruction and come back after 10 minutes.
Even my lord, I am for the petitioner, my lord, this interest from gratuity matter. This is my lord died in harness single PPO, my lord. The nominees have come, my lord.
This is wife.
My lord, wife and son and daughter, my lord.
Wife, son, and daughter. Where is the PPO?
My lord, PPO is page, my lord, 14, my lord. All 3 years there.
Mukul Roy, equal share. Sneha sees and Sneha. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioners seek direction upon the respondent authorities for grant of interest on delayed payment of gratuity and arrear pension amount from the date following the date of death of the petition.
The employee concern only.
The
Why do
petitioner,
you
my
write
lord, are
husband?
supposed to
Husband and or
Not
my lord,
husband.
husband
It is-
and or my lord father.
Husband.
Yes, my lord. Wife also come. And there is
Death of the petitioner's husband.
There are three
Petition number.
my lord, there are
Husband of petition number 1
there are three
Yes.
petitions.
and
till the date of actual payment along with interest 18% per annum.
My lord, there is no representation also corrected. Prior to filing the writ petition, they are supposed to file a representation to the concerned department.
The petitioners contain that the husband of petition number 1 and father of the other petitioners
my lord.
was an assistant teacher of Chandanpur Kumragori Primary School,
Primary school.
post Chandanpur district Hooghly. The husband of the petitioner died in harness on 2nd December 2011
Right.
after discharging his duties for 11 years.
11 years.
Upon demise of the deceased employee, pension payment order was issued on 20th June 2014.
June 14.
14. The gratuity and arrear pension amount was disbursed on
30th July.
30th July 2014. However, no interest was paid, hence this writ petition. Writ submission same. It is found that there is delay in disbursement of the bounden duty of the state to disburse that pensionary benefits upon demise of the deceased employee forthwith. Accordingly, it took 8%, 8 weeks from the date following the date of death of the deceased employee till the date of actual disposal. Equal purpose, equal. What is your matter? That your that matter?
As per list, as per list.
After all these matters, 47 is your 48. After this matter, take.
I have also state, my lord.
This is also same matter, my lord.
Instruction I have received, my lord, from the
Petitioner himself come here.
the instruction.
This is single PPO.
No, my lord, this is revised PPO.
ROPA?
For ROPA 19,
my lord.
ROPA 19.
ROPA 2019.
Just on gratuity and
The report affidavit of service filed on behalf of the petitioner is taken on record. The instruction filed by this District Inspector of Schools PE Malda dated 7. You are for state or
Not a state, my
state?
state.
Malda dated 7th August 2026 is also taken on record.
But there were some objections by the DI. There
কি বললাম? Huh. Taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authority for grant of interest on
Gratuity and
delayed payment of gratuity and area pension amount. ROPA 2019.
Right.
The petitioner contains that he was an assistant teacher of Mohish Bathani
Mohish
New
Bathani.
Setup Primary School, Village Mohish Bathan, Barkol District, Malda. The petitioner retired from service on superannuation on 30th September 2017.
First PPO issued on
The first pension payment order was issued on 14th September 2017.
and the revised PPO.
The revised pension payment order under ROPA 2019 was issued on
29th December 2021.
29th December 2021. The revised gratuity and arrear pension amount was disbursed on
6th January 2022.
2. ROPA from, where is that PPO?
PPO is for
14th February 2020.
right. This is my lord page 41.
Mr. Swenso, learned advocate appearing for the state submits that the revised pension payment order could not be issued since certain objections were raised from the end of the district inspector of schools, due to which there is delay in which resulted in delay. From 14th February 2020.
Right. Good.
Next.
This is also my lord ROPA 19 revised PPO. Petitioner himself come, my lord.
This is ROPA 2019.
My lord.
Yes.
ROPA 2019.
Gratuity and revised
Petitioner contains that petitioner.
My lord,
Petitioner contains that he was an assistant teacher. He joined as an assistant teacher on which date?
My lord, joining list is not there, my lord. Where the
petitioner was an approved head teacher of Tinsata Bigi Primary School, Village Tewari Tola, District Malda. Affidavit to উপরে নিয়ে নেবে. The petitioner retired from service on superannuation on 30th June 2020.
30th June.
The first pension payment order was issued on 12th June 2020. Yes?
12th June 2021.
The revised pension payment order under ROPA 2019 was issued on 25th February 2022. The revised area and gratuity amount disbursed on
27th February 2022.
27th
February
2022. However, no interest was paid, hence this writ petition.
And previously, my lord, it will be 3rd July 2020.
First pension.
No,
first disbursement matter.
Disbursement.
That is not required. He is not claiming that.
Yes.
ROPA 14th February 2020. দেখুন তো এটা রিটায়ার্ড হয়েছে 30th জুন। ঠিক, from 14th February 2020 till the date of actual payment, 8%.
The petitioner himself come, my lord. This is single PPO.
The petitioner, single PPO.
Single PPO.
Petitioner contains that the petition that he was an assistant teacher of Allahabad Primary School, village Allahabad, post Rajapur, district Malda. The petitioner retired from service on superannuation on 31st January 2021. The pension payment order was issued on 31st December 2021. The gratuity and arrear pension amount was disbursed on
18th December
2021. However, no interest was paid from the date following the date of retirement till the date of actual payment. Disposed of.
And for the respondent, ballot stated.
State.
Ballot, I am for
Okay. Affidavit of
Affidavit of service and corrected order.
this is ROPA 2019.
Yes, Lord.
Petitioner contains that he was an assistant teacher of
He was a head teacher, Lord.
petitioner retired from service, was an approved head teacher of Kotolpur Siptola Primary School, post Kotolpur district Bankura. The petitioner retired from service on superannuation on 31st July 2017. The first pension payment order was issued on 4th July 2017. The revised pension payment order under ROPA 2019 was issued on 21st June 2024. The revised gratuity and arrear pension amount was disbursed on which date?
Lordship, I received the amount on 3rd July 2024.
3rd July 2024. However, no interest was paid. Hence, this writ petition, ROPA's submission same 14th February 2020 till the date of actual payment, disposed of. Stated in
Lordship, I am for the petitioner.
affidavit of service. State. Your
Ropa.
ROPA
Widow is before your Lord.
the petitioner contains that her husband
পরে আর একটা সার্ভিস করা হয়েছে মনে হয়।
husband late Mohammad Ataur Rahman
হেড টিচার Lordship.
was a head teacher of Wahidpur State Plan Primary School, village Wahidpur, post Dahua, police station Horishchandrapur, district Malda. The petitioner's husband retired from service on superannuation on 30th June 2018. The first pension payment order was issued on 6th June 2018. The revised pension payment order under ROPA 2019 was issued on 15th September 2021. The revised gratuity and arrear pension
13th September. It was
14th.
amount was received on 15th September. The PPO issued on 13th September, Lordship.
13th.
Yes, Lordship.
Oh yes, 13th September. No? The revised pension payment order 13th September. When did the husband receive that?
Lordship, the amount was received on 15th September 2021.
The gratuity and arrear pension amount was received on 15 September 2021.
After that, he died.
The petitioner's husband died on 14 December 2022. As no interest was paid, hence this writ petition. Rest same from 14 February 2020 till the date of actual payment. 8%, 8 weeks. Next. Sure.
Madam. Single PPO petitioner herself.
Affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities for grant of yes.
Because my lord, petitioner was suspended from her service on 31st October 2024. And after 70 days, pension payment order was issued. And after 80 days to that, gratuity amount and arrear pension amount were paid from Central Bank of India. And but there is no such rule that all the payment will be disbursed after the next day of retirement. It will take time. Only after 70 days he got pension, and after 80 days to that he got everything.
April, 1st April.
When did you receive that?
1st April to 2025, my lord. About 6.
1st January.
1st January PPO issued, my lord.
3 months delay.
With 31st October 2024.
Payment was issued in April.
Only after 70 days, pension payment order was issued.
Disbursement made, my lord, disbursement made on April, my lord.
1st April.
My lord, 1st April.
After 80 days to the issuance of the pension payment order.
Whatever we calculate that and give that interest.
My lord.
Ulam. The petitioner was an assistant teacher of
Mirzapur, my lord.
PL Primary School. Post Mirzapur Police Station, Pakuria District, Malda. The petitioner retired from service on superannuation on 31st October 2024. Pension payment order was issued on 10th January 2025. Pension payment order was issued
10th January, my lord. Retired on 31st.
Gratuity and arrear pension amount was disbursed on
1st April 2025.
1st April 2025. However, no interest was paid, hence this writ petition. Or update following the date of retirement till the date of actual payment. 8%, 8 weeks. Disposed of. On submission, learned advocate for the state submit that there is no such delay in disbursement, inordinate delay in disbursement of the amount. Hence, and as such, the petition is not entitled to interest on the gratuity and arrear pension amount. For to follow the bill, it is a bounden duty of the state to disburse that amount. We cluster the other. Disposed of.
No, I am for the petitioner. This is also single PPO. Petitioner herself come, my lord.
Affidavit of service filed on behalf. Petitioner single PPO.
Not a single PPO.
Petitioner contains that he was an assistant teacher of Kalimela Vidya Niketan, Pratap Bagan District, Bankura. The petitioner retired from service on superannuation 30th November 2020. The pension payment order was issued on 25th October 2021.
25th August, my lord.
25th August 2021. The gratuity in arrear pension amount was disbursed on
1st September 21.
September 2021. However, no interest was paid, hence this writ petition from the date following the date of the retirement till the date of actual payment. 8%, 8 weeks. Doctor?
Lordship, I am for the petitioner.
Pass over to Doctor. Pass over to Doctor. Yeah, ঠিক আছে, এটা দাও 50. Affidavit of service.
স্লিপটা দিয়ে দিয়েছেন?
Is died in hardness, Lordship. Widow has come before your Lordship. Single,
In harness.
single people, Lordship.
The petitioner contends that her husband late Topon Kormokar was an assistant teacher of Chouduar Primary School, District Malda. The petitioner's husband died in harness on 11th November 2018 after discharging duties for 18 years. The pension payment order was issued on 4th April 2019. The gratuity and arrear pension amount was disbursed on 18th April 2019. However, no interest was paid, hence this petition. Rest same from the date following the date of death of the petitioner's husband till the date of actual payment. Document.
Your Lordship, after the last report which was filed, which was dated 1st of June, a notice was issued to the petitioner for production of certain documents. As I have been instructed, this has not been complied with by the petitioner. And further, the authorities would be also sending certain new notices wherein she would be required to.
No, my lord, what has happened?
I've handed over a copy of the notice to the petitioner.
My lord, kindly look this last report filed by this, not 1st June 2026. My lord, interrogation is all are completed. My lord, last page of this report. Last page of this report.
What is the date of the report?
1st of June. May I hand over the copy, Your Lordship?
1st June.
I have a spare copy, Your Lordship.
My lord, last page of this report. Last portion, my lord, during investigation notice, so and so sought allege so and so through so and so joined investigation when she did not respond and joined the investigation. My lord, HC Raj Kumar was sent outstanding so and so PS Chatal district with Midnapur on 13 May 2026. My lord, I defer this, my lord, he come, this officer come, and my lord, I with my junior and my client and her father was there, my lord, as the my lord Howrah station, my lord. We have all supply all documents, my lord. One, my lord, this is the one my lord, this one form. We have fill up this form and my lord handed over this to this officer, my lord. I was there, my lord. Not his my lord.
On which date? On which date?
My lord, 13 May 2026.
And this notice was also received by you?
You don't have this notice, my lord. Today, my
Her
lord.
signature is there at the bottom, Your Lordship.
No, my lord, on this day, my lord, on this day.
We are not
my
talking
lord, my lord,
about,
this is the,
Your Lordship,
this is the blank page. Only, my lord, this notice, only, my lord, what has happened, my lord? I was there, my lord. Today, he has come, officer has come, but today only this purpose investigation, you sign these documents, my lord. Only, my
this
lord.
report is prepared on 1st of June. This notice asking her to come on 15th. What is my learned friend saying?
My lord, totally, my lord, I am no, my lord, extremely sorry to say, my lord, I have
The
no
investigation
base
is
of
going on in
investigation,
Delhi.
My lord,
If he wishes to challenge that investigation, it has to be done in Delhi. It can't be here. My learned friend wishes to challenge the investigation. The territorial jurisdiction wants him to go to Delhi and challenge it. The criminal proceedings is pending there. Before
It is challenging the criminal proceedings.
it is at the stage of investigation wherein even handwriting samples have been called forward, Your Lordship.
Several order was passed, my lord. NIT lodged a complaint with force of this honorable court, my lord.
No, because there was a law permitting us to lodge a complaint, my lord. My lord, that Public
to
Examination
start
Prevention of
counseling
Unfair
candidates.
Means Act. Under that act, my lord, this complaint was lodged.
Lord, kindly, my lord, this
No,
is
no.
the
On the last date, I have asked for a status report
Your Lordship.
of the investigation.
Your Lordship.
Now you are producing a notice. It is not
Your
a
Lord-
report.
Your Lordship, the report.
Correct. Now, if you say that on 15 June you are supposed to produce that, that has not been produced. So we are in August now.
Your Lordship. Meantime, we have also issued.
After he has not complied, even if I say or I can accept your contention that there was a notice served asking him to produce certain documents on 15 June. If it has not been complied with, this was never indicated on 18th or in August.
Yes.
Your Lordship, because Delhi police was not being represented. Only today is the first. Last day, I appeared and took notice, and today I am appearing on behalf of Delhi police.
This
Your
notice
Lordship.
has not been complied with.
Your
Then
Lordship.
subsequently they might have also issued a notice of non-compliance that you such and such notice was given. So final date is this. You come and produce the documents.
Your
That
Lordship.
notice you have not issued, or there is no such notice. After June, we are in August.
Your Lordship.
So
in August, they have also issued a notice wherein calling the petitioner for handwriting
where is that?
sample.
He says that there is no notice.
Your Lordship, I have handed over this notice to my learned friend.
Where is that? This is dated. No date is there. But asking him to present on 15 June. We are in August. In between this period, what steps have been taken?
Your Lordship grants me 2 weeks time to file a
No,
proper.
madam, you are not understanding. It's not the matter of taking 15 days or 1 week. What is the status of investigation? They have come over to Calcutta. They have investigated, interrogated his client. Now you say that there are certain documents. He says that no such notice was served.
Your
What
Lordship.
is your status?
Your Lordship kindly
Is
sees
that
the.
status report?
Lord, kindly so.
By
This
filing
But
documents.
no.
Notice.
I have handed over right
No,
now.
only
You
report. Only report.
What are you talking about? I have just given you the notice copy.
You show me that, my lord, kindly, my lord, date. This is the pen and paper, my lord. That on that day, my lord, 13 May, they not, my lord, my lord, mention this date. Only, my lord, 2 days before, my lord, he has, my lord, wrote this date, my lord. I am categorically saying, my lord, I was present at the time of interrogation. My client.
Blank paper was signed
No,
in
my
your
lord, only,
presence.
yes, not blank paper.
What is your name, madam?
Interrogation
Your Lordship.
purpose,
What is your name?
Your Lordship, Advocate Anamika Pandey, Your Lordship.
Please don't answer to what is. You just answer to my queries.
Your Lordship.
That what is your status report right now?
It's under investigation. Your Lordship, there's.
You have to state that fact.
Your Lordship.
By producing a notice, how can the court take cognizance of this?
Your Lordship.
So inform the court that this is the fact. They say they are disputing that no notice has been served. On pen and paper, you say that the notice was served on such and such date. He has not produced.
Your Lordship.
From June to August, within 2 months, nothing has happened. Nothing. If there is any notice, he says there is no further notice. There is no further notice with you as well.
Your Lordship, this is the last notice which we had issued. And they subsequently, they are.
It has been submitted.
No, still under investigation.
State that.
Your Lordship.
This was the reason I asked the petitioner to serve a copy on the Union of India.
Your Lordship.
Because the NTA was not having the status report. But that is not there. You are producing a notice, only copy of the notice will serve. Where is Mr. Dwivedi? He has not come.
Your Lordship, he is out of station due to personal difficulty. See.
But this is making the things difficult, no?
Your Lordship, I am.
At the instance of the court, you have lodged the.
I'm for the NTA, my lord, national test.
NTA has lodged the FIR.
Yes,
Your
it
Lordship.
was.
My lord,
NTA has
after, my lord, Justice, my lord, Basu said, categorically said at the time of hearing, why court is passed this order? You have responsibility that, my lord, what has happened, my lord? Kindly, my
Our
lord,
contention is, my lord, is
kindly, my lord.
courts, if OMR, my lord, she has filed this.
No,
writ
my lord,
petition.
what has
That
happened,
is
my lord,
our
kindly
contention.
read petition. My lord, have a look this read petition.
Your
My read
Lordship,
petition, my
there
lord.
are two
What has
documents
happened,
which
my lord?
has to be compared. One, the original on the website, what the OMR sheet is there. and what petitioner has produced here. The document affirmed,
have a look
Your
this
Lordship, the
writ
document
petition.
affirmed before Your Lordship is the affidavit.
You say that the OMR which has been attached to the writ petition is not the original one.
Yes, that is our contention. That is exactly why, my lord, with leave of the honorable court, my lord, we have lodged this complaint because that time this act came into force, the Public Examination Prevention of Unfair Means Act. Under that, this complaint was lodged, my lord.
Okay.
The first page of the report also states that, in the first paragraph.
My lord, kindly read petition page number 18. What has happened, my lord? Page number 18 of my read petition. My lord, kindly, my lord, have a look. This read petition page number 18. My lord, what has happened, my lord? 14 June, my lord, result was published. My lord, before this, my lord, one my lord, weeks ago, my lord, this is the norms of this NTA, my lord. They sent all the student, my lord, sent to the OMR, and my lord, next page is my lord booklet. Next page is my lord booklet answer script. My lord, I received the same, my lord, and my lord, I think so. This is the original documents, my lord. My lord, after my lord 14 June, my lord, I received from mail, my lord, through mail, my lord, on 1 week ago, this OMR sheet and my lord answer script. My lord, what has happened, my lord? 14 June, result was published by this NTA. After that, my lord, on this evening, my lord, I sent a mail. This is not my result. It would be assessed. I would get this number 580 out of 700, not 128. My lord, this is our case. My lord, I wrote a letter. My lord, page number 20. And my lord, what has happened, my lord? I filed this petition, my lord. After that, my lord, NTA, my lord, learned lawyer of this NTA, my lord, produced the one OMR sheet. Simple as that, my lord. What has happened, my lord, is he supply me one OMR sheet. I filed this supplementary affidavit by this order of this honorable court, my lord. Kindly looks this my affidavits, my lord, supplementary affidavits. Lord, kindly have a look this my supplementary affidavit.
You have produced the original OMR.
Original was not called for, my lord. In this matter, original was not called for. We have produced, my lord, the copy, the scanned copy which was available on the website.
Yes, my lord, my first prayer is, my lord, produce this original
Because
sheet.
on
The
the
matter
Your
is
Lordship,
that
Here,
the
my lord,
original
number of
OMR sheet would be required in the criminal investigation. Without that, they would not be able to proceed. A true certified
But
copy
the
could be
original
produced.
OMR will be also required for adjudicating the matter. He says he's not, he's getting 580.
Your Lordship, there are two issues here.
Claim which has been made by the petitioner, it should be adjudicated that is the incorrect. Then the original has to be there.
Yes.
Why it is incorrect?
because
Your Lordship, there are two issues here. One, the petitioner alleging that she would get 580. The department said that this is not a correct OMR sheet. She has forged a document and put it in a writ petition. Honorable Court directs that take appropriate steps in accordance with law. In terms of court's order, they lodge an FIR. Today, we are in the stage of investigation.
because last year,
Without-
I tell your lordship,
that
number
OMR
of
Without
researchers
going
were
with-
filed
Your
with
Lordship-
fake OMR sheets, my lord.
So you
All were withdrawn except this.
file the status report. What is the findings of the investigating agency? What during interrogation, what has transpired, that should be reflected in the status report.
Your Lordship.
My lord, only, my lord, this is
On
the one
other-
mail, my lord,
Sir,
one
please.
investigation
The
is going
email,
on.
the email by which she's alleging that she had received it, whether that was correct or not, that has to be looked into. That would be evident from which email address, what was the IP address, where it was downloaded. So these factors has to be investigated and brought to a conclusion. And the website which has, that's a third party agency which collects all these data with regard to the examination. It is not the government or the investigating agency. It's a third agency which collects and maintains those data for fairness.
That is
So-
NIC, my lord.
NIC.
National Information.
So that document is available on the website. it is apparent. When an authority has stated that this is not the correct OMR sheet which she is alleging to have received, and a subsequent OMR sheet has been filed, Your Lordship can direct the authorities, NIC, to produce it by way of an affidavit.
You file the status report first.
I will, Your Lordship.
And my lord, one thing I can say, my lord.
If it is ready, file that. What is the interrogation? 10 দিনের মাথায় date বলো।
It will be completely documentary evidence mostly.
Huh? 7. Accommodation is sought for on behalf of Union of India.
Delhi Police, Your Lordship.
Delhi Police is not the party. Union is a party, no?
Union is a party, Your Lordship. I am appearing for Delhi Police.
Delhi Police,
Delhi Police.
not Union of India.
No, Your Lordship. Union of India is being represented by my learned ASG, Dheeraj Trivedi, and Arijit.
Your name is also there.
Your Lordship.
On the last date you appear.
Your Lordship, for Delhi Police.
Not for Delhi
No,
Police.
no, my lord.
Through
I appeared online.
Consular General also mentioned, my lord, I appearing with my lord, Miss Amrita Pandey.
Anamika.
You are representing the Union or the Delhi Police?
Delhi Police, Your Lordship.
Not the Union.
Not the Union.
None appears on behalf of the Union of India. Miss Anamika Pandey, learned advocate representing. Wait, Delhi Police is a party here?
Your Lordship had called for a report
my lord.
on behalf of
At the time of filing, my lord, there was no role, my lord.
Okay.
After 3 hearings, my lord,
Appearing on behalf of the investigating agency seeks accommodation to file the status report of the investigation. Release this matter on 7th September. Petitioner is learned advocate for the petitioner directed to intimate the office of the next date, office of ASG of the next
We'll
date.
inform them. Your Lordship, I'll update the. I'll inform the learned ASG.
Learned advocate for the you give a notice. 7th September, same heading. Next. Six.
Yes. My lord, what has happened is after 11th of August, even though with regret I submit, this 11th of August order was not communicated upon the DPSC, my lord, and that has happened because after 11th of August, the advocates panel for the DPSC South 24 Parganas, that has been changed. Today, I am appearing for the first time in this matter on behalf of the DPSC.
7 days time is given. Next week this will appear. In the meantime, you communicate this order.
Deeply utilized. My lord, 10 days time would be
learned advocate. What is your name?
Pronoy Boshak.
Pronoy Boshak, learned advocate for the alleged contemner, submits that since there was change in the panel of learned advocates.
Yes, for the DPSC.
Learned advocates for DPSC, South 24 Parganas. The previous order could not be communicated to the alleged contemner for future further course of action. He seeks accommodation to comply the previous order dated 11th August 2026. 7. The alleged contemner is directed to take steps in terms of order dated 11th August 2026. Release this matter on 7th. On same heading. Affidavit of compliance be filed by the returnable date. All parties to act on the charge. 7.
Deeply obliged.
Great.
তখনই দিয়ে দিচ্ছি। হ্যাঁ
Interest on gratuity and single PPO petitioner himself come.
নীলাঞ্জন না? নীলাঞ্জন বলবে এই নীলাঞ্জন বলবে গৌতম বাবু শ্রীমানি বাবু একটা শ্রীমানি বাবুর কাছে নিয়ে রাখবেন ওটার তো আছে একটা সিঙ্গেল পিপিও একটা Affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner's seeks direction upon the respondent authorities to grant interest on delayed payment of gratuity and arrear pension amount from the date following the date of retirement till the date of actual payment at the rate of 18% per annum. The petitioner contends that he was an assistant teacher of Bhandir Khali Dvijabar FP School, Post Bhadro Khali, District North 24 Parganas. The petitioner retired from service on superannuation on 31st May 2020. The first pension payment order, single PPO this is?
Not single PPO.
First pension payment order was issued on 10th May
10th May
2021. The gratuity and arrear pension amount was disbursed on 15th May 2021. However, no interest was paid, hence this writ petition. এই হলো rest submission সহজে পেয়ে যাবে single PPO from the date following the date of retirement till the date of actual payment disposed of 8% 8 weeks.
And this is also single PPO and petitioner himself come.
Single PPO. Affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities for grant of interest on delayed payment of gratuity, both gratuity and arrear, both.
My lord, both.
Gratuity and arrear pension amount from the date following the date of retirement till the date of actual payment at the rate of 18% per annum. Grant of 8%. Petitioner contains that he was a head teacher of Ramnagar Junior Basic School, Post Ramnagar, District Malda. The petitioner retired from service on superannuation on 31st August 2001. The pension payment order was issued on 7th February 2002. The gratuity and arrear pension amount was disbursed on 19th December 2025. No. On 2nd September, no? What is the date of receipt of that?
My lord, 2nd September 2003, my lord.
No. Which is the date of disbursement? Indian Bank. Yes, 2nd September 2003 with the 19th of category. However, no interest was paid, hence this writ petition. এখানে ডিলে ক্লজ আছে ওটা বলবেন ডিলে ক্লজ তো ওটা বললেই দিয়ে দেবো ওই ক্লজটা ঢুকিয়ে দেবো বলে দিচ্ছি বলে দিই it is found that there is delay of more than 22 years in claiming such interest. Be that as it may, rest ওখান থেকে পেয়ে যাবে delay clause 8% from the date following the date of retirement till the date of actual payment. Disposed of. 8 weeks, 8%.
But I'm for the question. This died in harness, my lord. The nominees have come, my lord, for the revised PPO, my lord.
Wife.
My wife and the yes, my lord, only wife has come. my lord. Only wife has come.
Revised.
My lord, revised.
She also moved a writ petition.
My lord.
Prior to this, she has moved a writ petition. That was single PPO. Item number 15.
Oh, my lord, maybe this is the first PPO, okay? Single PPO, no?
Yes, sir.
Yes, ma'am. Single PPO.
This is revised under
ROPA 19.
That is after ROPA 19.
ROPA 19. ROPA 19.
Yes.
A petitioner রূপাটা নিয়ে নেবেন উপরে যা থাকে ওখানে পেয়ে যাবেন The petitioner contains that her husband late Devashish Sarkar Topon Kormokar was an assistant teacher in Chouduar Primary School, Chouduar District, Malda. The petitioner's husband died in harness on 1st November 2018 after discharging duties for 18 years.
The first PPO issued on my lord,
First pension payment order was issued on 4th
April
April 2019. Stop. The revised pension payment order under ROPA 2019 was issued on 14 September 2021. However, no interest was paid, hence this writ petition. 8%, 8 weeks from the date of effect of ROPA, that is 14 February 2020, till the date of actual payment. It revised when the revised was granted?
My lord,
18 September.
My lord, disbursement on my lord.
The revised gratuity and area pension.
My lord, 18 September 2021.
Was disbursed on 18 September 2021. Revised token for disposed of. It revised ROPA 2019. একটা সাজিয়ে নেবেন বাকিটা হয়ে যাবে Next.
My lord, interest on gratuity and area pension, ROPA 19 revised PPO, my lord, petitioner himself come.
ROPA 2019.
My lord.
The petitioner ওপরটা same 2019 এ যাওয়া হয় affidavit of service হলো petitioner contains that he was an assistant teacher of Nauda Primary School, Post Babupur, District, Malda. The petitioner retired from service on superannuation on 28th February 2017. The first pension payment order was issued on 28th February 2017. The revised pension payment order under ROPA 2019 was issued on 1st June 2021. The revised gratuity and arrear pension amount was disbursed on
6 June 2021.
6 June 2021. However, no interest was paid. Where is the revised pay? 14 February 2020 till the date of actual payment. 8%, 8 weeks.
Grateful.
Widow is before your lordship.
Widow.
Yes, Lord.
This is ROPA 2019.
Yes, Lordship.
2019.
Yes, revised review 2019.
The petitioner contains that her husband late Brojendranath Sarkar was an assistant teacher, no, was a head teacher of Ramchandrapur FP School, post Katabadi, district Dokhin Dinajpur. The petitioner's husband retired from service on superannuation on 28 February 2017. The pension payment order was issued on 6th March 2017. First pension payment order. The revised pension payment order was issued on
29th November.
29th November 2021. The revised gratuity and arrear pension was disbursed on 5th December 2021. Under ROPA 2019. However, no interest was paid, hence this writ petition. তার আগে একটা লাইন দিয়ে দিন, the husband of the petitioner expired on 2nd November 2022. 14th February 2020 till the date of actual payment. Disposed of. অর্ডার করা আপনি বললেন কেন? আমি তো ছেড়ে দিই। Dismiss for default থাকলে যে কোর্টের ডিটারমিনেশন সে নেবে। Seated advocate का देखे थे ये release कर दो নাহলে একটা কাজ করুন দেখে তুমি মেনশন থার্সডে তে রেখে দিন থার্সডে তে ওর আর কোনো দরকার নেই থার্সডে তে তুমি মেনশনে রেখে দিন স্টেটেড অ্যাডভোকেটকে ইনফর্ম করে দিন তুমি মেনশনে রেখে দিন নট টুডে হ্যাঁ দিন
21 also, Lordship, I am for the petitioner.
I'm for the statement.
single PPO
Yes, Lordship, single people.
petitioner contains that he was a head teacher of Sitaram Chuk Primary School post
Sitaram Chowk, Lordship.
Chowk post Goura district Paschim Medinipur. The petition retired from service on 31st January 2025. A pension payment order was issued on 30th June 2025. The gratuity and arrear pension amount was disbursed on 23rd July 2025. However, no interest was paid, hence this writ petition. 8%, 8 weeks. Same submissions.
This is ROFA 19 revised PPO, my lord.
ROFA 19. 14th February. Petitioner himself.
Petitioner himself come.
Petitioner was an assistant teacher, was a head teacher of Bhagwanpur HM attached primary school, Bhagwanpur, post Samsi, district Malda. The petitioner retired from service on superannuation on 31st January 2016. The first pension payment order was issued on 2nd February 2016. The revised pension payment order on RUPA 2019 issued on
15th March
2021. The revised gratuity and arrear pension was disbursed on 22nd March 2021. However, no interest was paid, hence this writ petition. Fourteenth February 2020. Mr. Sengupta, your opinion? Disposed of.
Published.
Oh, yeah. Interested from the date of effect of RUPA, that is 14th February 2020 till the date of actual payment.
My lord, I am for
23 as well.
Interest on gratuity and arrear pension, single PPO, my lord. Petitioner himself.
PPO retired as assistant teacher. No? He was an assistant teacher of Pindor Boni Primary School, village, post Ruth Khanda, district Bankura. The petitioner retired from service on superannuation on 30th April 2020. The pension payment order was issued on 19th February 2021. The gratuity and arrear pension was disbursed on
4th March 2021.
4th March 2021. However, no interest was paid from the date following the date of retirement till the date of actual payment. 8%, 8 weeks. Disposed of.
Man. This is also single PPO, my lord. Petitioner himself come.
Affidavit of service filed on behalf of the petitioner is taken on record. Single PPO?
Single PPO.
It was single PPO. The petitioner was a head teacher of Prasadpur Primary School, Post Jaipur, District Bankura. The petitioner retired from service on 31st December 2019. The pension payment order was issued on 13th December 2020. The gratuity and arrear pension amount was disbursed on
disbursed on
4th January 2021. However, no interest was paid, 8% from the date following the date of the retirement till the date of actual payment. Mr. Sengupta is appeal.
25. 25 for the petitioner. Revised PPO lordship, petitioner was the employee lordship.
Revised. ROPA 2019. The petitioner contains that he was a head teacher of Balupur MGD Primary School, Post Balupur, District Malda. The petitioner retired from service on superannuation on 31st December 2017. The first pension payment order was issued on 9th March 2018. The revised pension payment order was, as per ROPA 2019, was issued on 14 June 2022. The revised gratuity and arrear pension amount was disbursed on 16 June 2022. However, no interest was paid from the date February 2020. From the date of effect of disposed of.
And for the petitioner, revised PPO, petitioner was the employee lordship. Affidavit of sale.
Petitioner himself.
Yes, lordship.
The petitioner contains that he was
Head teacher.
a head teacher of Kanchanpur Primary School, Post Trishanol, District Bankura. The petitioner retired from service on superannuation on 30th September 2016. The first pension payment order was issued on 3rd August 2016. The revised pension payment order under ROPA 2019 was issued on 21st May 2021. The revised gratuity and arrear pension amount was disbursed on which date?
Revised amount I received on 27th May.
27th May 2021. However, no interest was paid from the date of effect of ROPA, that is 14th February 2020 till the date of actual payment. 8 weeks, 8%.
Twenty-seven lordship, I am for the petitioner. Revised PPO, petitioner was the employee lordship.
Petitioner himself.
Yes, lordship.
Petitioner contains that he was an assistant teacher of Saraswati Vidyapit, Nutan Pukurpad, District Bankura. The petitioner retired from service on superannuation 30th April 2017. The first pension payment order 25th April 2017. The revised pension payment order under ROPA 2019 was issued on 22nd May 2021. The revised gratuity and arrear pension amount was disbursed on 17 June 2021. However, no interest was paid. Hence, this petition 14 February 2020 till the date of actual payment disposed of.
And that statement.
Lordship, I am for the petitioner.
ROPA.
Yes, lordship.
ROPA.
19 petitioner was
Petitioner was an assistant teacher of Mahamaya Primary School, Moira Band District, Bankura. The petitioner retired from service on superannuation on 29 February 2016. The first pension payment order 22nd January 2016. Revised pension payment order under RUPA 2019 was issued on 10th February 2021. The revised gratuity and arrear pension amount was disbursed to the petitioner on 23rd February
2021, Lordship.
2021. However, no interest was paid. 14th February 2020 till the date of actual payment disposed of 8% 8 weeks. Bhai.
I am for the petitioner, Lordship. Died in harness, revised with your Lordship.
Affidavit of service. Petitioner contains that how many petitioners are there?
Two, Lordship. The
Two.
widow and the son.
Petitioners contain that the deceased teacher being the husband and father of petition number 1 and 2 respectively was an assistant teacher of Chhatabedia AP School, post Chhatabedia District, South 24 Parganas. Stop. The deceased employee, the employee died in harness on 10th December 2016. The first pension payment order was issued on 4th June 2018. The revised pension payment order under RUPA, page number
Lordship, annexure P3, Lordship.
under RUPA 2019 was issued on 28th April 2025. The revised gratuity and arrear pension amount was disbursed on 1st June 2025. However, no interest was paid, hence this writ petition. Post February 2020 till the date of actual payment. In equal share. Equal share to শ্রীমানি বাবুর কাছে আছে equal share. এই ল্যাঙ্গুয়েজটা দেখে নেব।
The single PPO petitioner himself.
The petitioner contains that he was an assistant teacher of Baipukur Lane Primary School, post Vidyasagar University, District Paschim Mednipur. The petitioner retired from service on superannuation on 31st January 2018. The pension payment order was issued on 6th July 2018. The gratuity and arrear pension amount was disbursed on date
August
3rd August.
1st August.
1st August 2018. However, no interest was paid, hence 8% from the date following the date of retirement till the date of actual payment, 8% 8 weeks disposed of. Mr. Sengupta, you are appearing.
30-31. My lord, I am for the petition. This is also
Affidavit of service.
Single PPO, my lord. Petitioner himself come.
The petitioner contains that he was an assistant teacher of Chingud Don Primary School, post Mahilal Chowk district, Purbo Medinipur. The petitioner retired from service on superannuation on 30th June 2025. The pension payment order was issued on 24th November 2025. The gratuity and arrear pension amount was disbursed on
3rd December, my lord.
3rd December
2025.
2025. However, no interest was paid, hence this writ petition. 8% 8 weeks from the date following the date of retirement till the date of actual payment. Disposed of.
I'm grateful.
31, 32.
But single PPO, madam.
The petitioner contains that he affidavit of service contains that he retired. No, he was an assistant teacher or head teacher. She was an head teacher. She was an head teacher of 9 Amorendranath Primary School, post Azimganj district, Murshidabad. The petition retired from service on superannuation on 30th April 2022. The pension payment order was issued on 13th June 2023. The gratuity and arrear pension amount was disbursed on which date? 19th June 2023. However, no interest was paid. 8% 8 weeks from the date following the date of retirement till the date of actual payment. Disposed of.
Malad, petitioner was the driver, Malad. He was the driver of the district primary school council, Bardhaman. Paragraph 2, Malad, have written. Veto is before your lordship. Page 2, Malad, have written. Page 2, para 2. Death certificate is annexed to P1, page 13.
Rupa, this is.
Malad, this is Rupa.
আসুন। ড্রাইভারের ক্ষেত্রে কি আমাদের ডিটারমিনেশন আছে? ড্রাইভারের নন টিচিং স্টাফের ক্ষেত্রে আছে কি আমাদের ডিটারমিনেশন? The driver of a DPSC, this was a determination to deal with this.
Primary education.
DPSC will be there. No?
District primary school education. This is primary school council. Primary school council.
Chalo. The petitioner contains that her husband, late Hossein Begum, no, late Sheikh Shamsir Alam, was a driver of employed in District Primary School Council, Bardhaman. The petitioner's husband died in harness on 20th January 2018. The pension payment order was first pension. This is revised.
Revised people.
First pension payment order was issued on 25th September 2018. The revised pension payment order under ROPA 2019 was issued on 20th July 2021. The revised gratuity and arrear pension amount was disbursed on which day?
Second one, 3rd of
3rd August 2021. However, no interest was paid. 14th February 2020. Disposed of 8 weeks, 8%.
I was going to say.
Stated, you know, it's in book 34.
but the here the kind of petitioner is the clerk, was the clerk of the district primary school council. Petitioner himself.
Petitioner was an upper division clerk of District Primary School Council, Bardhaman, District Purbo, Bardhaman. The petitioner retired from service on superannuation on 31st January 2016. The first pension payment order was issued on 18th January 2016. The revised pension payment order under ROPA 2019 was issued on 31st January 2022. The revised gratuity and arrear pension amount was disbursed on 7th February 2022. However, no interest was paid. No, sorry, however, no interest, hence the state petition. 14th February 2020 till the date of action. Disposed of. Yeah.
And for the petitioner, single PPO. The petitioner retired as an assistant teacher.
The petitioner was an assistant teacher of Milikpada AP School, Post Simdol, District Purbo, Bardhaman. The petitioner retired from service on superannuation on 31st August 2021. The single PPO.
Single PPO.
The pension payment order was issued on 2nd December 22. The gratuity and arrear pension amount was disbursed on 8 December 2022. However, no interest was paid.
Petitioner.
जी.
Single PPO मतलब.
It was single PPO.
Retired as an assistant teacher.
The petitioner was a head teacher of Giara AP School, Post Barakashiara, District Purbo, Bardhaman. The petitioner retired from service on superannuation on 31st January 2020. The pension payment order was issued on 2nd November 2020. Gratuity and arrear pension amount was disbursed on 9th November 2020. Upon interest was paid. Retirement of from the date following the date of retirement till the date of actual payment. 8% 8. State who is represented?
My lord. But I'm for the platform. The widow is before your lordship. The employee my lord, died after superannuation.
Wife. Harani. Single PPO? No, ROPA.
My lord, this is Ropa.
Petitioner contains that her husband late Anon Kumar Hajra was an assistant teacher of Joyrampur Tripali AP School Post Joyrampur District Purva Bardhaman. The petitioner's husband retired from service on superannuation on 31st October 2016. The first pension payment order was issued on 18 November 2016. The revised pension payment order was issued on 31st May 2022, RUPA 2019 बोलो ना, revised pension payment order under RUPA 22. The revised gratuity and arrear pension amount was disbursed on 7 June 2022. The petitioner's husband expired on 12 November 2024. However, no interest was paid, hence this writ petition. From the date of effect of RUPA, 14 February 2020 till the date of actual payment. 8%.
Yes. My lord, we are for the petition. Sorry, respondent. My petition.
But I'm for the petition, my lord. My lord, here, my lord, son is before your lordship. Both his parents, my lord, expired, my lord.
Son.
Son is before your lordship. Annexed both the, my lord, death certificates. Father was the employee. Was upper division clerk, my lord.
The petitioner's father was an approved upper division clerk under District Primary School Council, Bardhaman. The petitioner's father retired from service on superannuation on 31st January 2019. The first pension payment order was issued on first pension payment order
8 January 2019.
Miss Downey. Miss Lepon.
8 January 2019.
Pension payment is manual, but it is continuous.
The revised pension payment order under ROPA 2019 was issued on 23rd May 2022.
Yeah, I didn't put that.
The revised gratuity and arrear pension amount was disbursed on
7,000.
4th July 2022.
দিদি যতগুলো আছে সবগুলোতেই আছো না?
ঠিক আছে, আমার তো লাস্টের গুলো।
কোথায় পোস্টিং এখন দাদা? হ্যাঁ,
The father of the petitioner expired on 4th April 2020. The mother of the petitioner predeceased his father and expired but died on 17th October 2012. Since no interest was paid on the revised gratuity amount, gratuity and arrear pension amount, the petitioner has referred the present writ petition for him from 4th February 2020 till the date of actual payment, disposed of.
Great.
9 वाला रिवाइज पेपर।
मैम मैडम
Instructions.
Single.
मतलब रिवाइज पेपर रोपा। He retired as a head teacher.
Petitioner himself.
Petitioner himself.
Petitioner was a head teacher of Sri Krishnapur FP School, post Kurumba,
The নামটাও দেখিয়ে দেন।
district Purbo Bardhaman. The petitioner retired from service on superannuation on 30th June 2018. The first pension payment order was issued on 30th October 2018. The revised pension payment order under RUPA 2019 was issued on 29th June 2022. The revised gratuity and arrear pension amount was disbursed on 1st July 2022. However, no interest was paid, hence this writ petition. The rest same from the date following the date effect of RUPA, that is 14th February 2020 till the date of actual payment. 8%, 8 weeks, disposed of.
Great.
But I'm for the petition.
Single PPO.
मतलब revised PPO, मतलब died in harness, मतलब your wife is before your lordship.
The petitioner contains that her husband, late Abdul Awal Mondol, was a head teacher of 23 Purbo Kashipur Primary School, post Kashipur district, Murshidabad. The petitioner's husband died in harness on 21st January 2017. The first pension payment order was issued on 10th November 2017. The revised pension payment order under RUPA 2019 was issued on 24th May 2021. The revised gratuity and arrear pension amount was disbursed on 13th August 2021. However, no interest was paid, hence this writ petition from effect 14th February 2020 till the date of actual disbursement. Next.
I am for the petition. RUPA 2019.
RUPA 2019.
Petitioner retired 31st August 2019.
Petitioner was an assistant teacher. Head teacher was a headmaster of 30 Lalnagar Primary School, post Naupada Simulia district, Murshidabad. The petitioner retired from service on superannuation on 31st August 2019. First pension payment order 16th September 2019, revised under RUPA 2019, 27th December 2021. Revised gratuity and arrear pension amount disbursed 3rd January 2022, no interest paid, from 14th February 2020 till the date of actual payment. Disposed of.
I am for the petitioner lordship. RUPA 2019, interest on gratuity and arrears.
2000?
Rupa 2019.
19. Only gratuity.
Interest on gratuity and arrear pension.
Petitioner himself.
Petitioner himself.
Petitioner contains that he was a head teacher of Sonapur, Sonakur Junior Basic School, Post Shaktigarh District, Purbo Bardhaman. The petitioner retired from service on superannuation on 31st May 2016. The first pension payment order was issued on 28th April 2016. The revised pension payment order under ROPA 2019 was issued on 7th March 2022. The revised gratuity and arrear pension amount was disbursed to the petitioner on 7th March 2022. However, no interest was paid. 14th February 2020. Okay. Till the date of actual payment, 8%, 8 weeks. Next.
I am for the petitioner. Single PPO.
Single
Interest
PPO.
on gratuity and arrear pension, Lordship.
Petitioner contains that. Petitioner himself.
Petitioner herself.
Contains that. He was an assistant teacher of 8 Maharani Kaseshwari Primary Balika Vidyalaya, Post Baharampur District, Murshidabad. The petitioner retired from service on superannuation on 31st October 2019. The pension payment order was issued on 5th December 2020. The gratuity and arrear pension amount was disbursed on 14th December 2020. However, no interest was paid in this. From the date following the date of retirement till the date of actual payment. 8%, 8 weeks.
I am for the petitioner, Lordship. Interest on gratuity and arrear pension, ROPA 2019.
Petitioner contains that. Affidavit is issued though. Petitioner contains that he was an assistant teacher of 69 Adamtola Bipod Bhanjan Primary School, Post Kalitala Dayar District, Murshidabad. The petitioner retired from service on superannuation on 30th November 2018. First pension payment order 15 November 2018. The revised pension payment order under ROPA 2019 was issued on 1st February 2023. The revised gratuity and arrear pension amount was disbursed on 1st February 2023. However, no interest was paid. 14th February 2020 till the date of actual payment.
For the petitioner, this is ROPA 2019.
ROPA 2019. Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner contains that. এই মাঝেরটা বলছি না ROPA 2019 উপর। Petitioner
was the employee.
Was an assistant teacher of Mankar SRC Free Primary School, Post Mankar District, Purbo Bardhaman. The petitioner retired from service on superannuation on 31st January 2017. The first pension payment order 18 January 2017. The revised pension payment order under ROPA 2019. 1st February 2022. The revised gratuity and arrear pension amount was disbursed on 4th February 2022. However, no interest was paid in this. 14th February 2020 till the date of actual payment. Disposed of. Sorry.
For ROPA 2019. He retired as an assistant teacher.
Assistant teacher of Amrargarh Ishan FP School, Post Amrargarh District, Purbo Bardhaman. The petitioner retired from service on superannuation on 28 February 2017. The first pension payment order, 13th February 2017, revised pension payment order under ROPA 2019, 20th December 2023. The revised gratuity and arrear pension amount was disbursed to the petitioner on 12th January 2024. However, no interest was paid, hence this writ petition. 14th February 2020 till the date of it. Disposed of.
I am for the petition only. My lord, I am for the. Your lordships, my lord, heard this matter, my lord. This is relates to my lord provisional pension of a my lord primary teacher, my lord. My learned friend, the last occasion, my lord, referred the rule 1905, my lord. So, my lord, I am entitled to get, my lord, provisional pensions during pendency of a my lord criminal proceedings. It does not bar, the rule does not bar. Only my learned friend wish to my lord submit a report. My lord, I got the report over WhatsApp, my lord. I am kindly excuse me, my lord. And
One vote. No second granted thereafter. Denying the office of period had no excess there is no adequacy for continuing.
what is it? What is it?
Yes.
Lordship. My lord, the stoppage of the provisional pension that they have, my lord, given the explanation, and my lord, as there are other provision with regard to the my lord, circumstances that the petitioner as of now, my lord, is having in his favor, my lord, there are other provision in the DCRB itself, because there is a criminal case pending against him under the my lord, Immoral Trafficking Act. My lord, it is having a color of moral turpitude. There is a provision 1905. In that event, my lord, a interim allowance can be extended to the petitioner. My lord, in the for my lord, considering that aspect, as my lord, and there is a representation pending in before the authorities also. My lord, let the matter be delegated back to the my lord, pension sanctioning authority to take a decision over the issue, considering the my lord, specific case that the petitioner for the time being is my lord, having that kind of status, and to take all consequential step, my lord, in accordance with law. Very well, my lord. My lord, another thing,
Therefore,
my lord,
I am entitled to get the
only
provisional.
Not provisional.
Provisional.
Interim.
Interim.
My lord, only one thing, my lord, we are having it can be said no documents. We need a my lord, a cooperation from the petitioner.
Yes. Why I will not cooperate?
Yes, my lord, let a
It is
direction
in the
be given
They
to the
have stated all
petitioner.
these things in the report. Now they are saying
yes.
no documents. Even if Milord, I will cooperate. Milord. What is the
Because
issue?
my lord, let a direction be given so that he can render all sorts of cooperation.
Yes, yes.
Where is your representation?
My lord, it is at page 31, and before that, my lord, page 30 is also
30
there.
and 31 both.
30 is having a seal. 31 to name. 31.
At the top seal.
Top seal. Page 31 to be
31.
Yes, but the pension sanctioning authority is the secretary. Malo, let the 30 be directed to be considered.
30 and 31, 30 is Milord in respect of DI of school, and 31 Milord Chairman Malda.
He is
Yes.
not the sanctioning authority.
Secretary, my lord, is DI primary is the secretary, ex officio secretary, and secretary is the my lord pension sanctioning.
30,
authority.
my lord, then.
Page 30 to be directed to be considered.
Where is that rule?
Yes, my lord, I
2009.
have handed over in the earlier occasion within the first volume, my lord. I'm
Volume 1.
volume 1. আমি দাঁড়ান আমি বার করে দিচ্ছি।
19. ফাইলে নেই ফাইলে থাকার কথাটা কথা আর একটু দিচ্ছি আমারটা দিচ্ছি
ঠিক আছে ধরো এখানে আছে, এখানে আছে আমি দিয়ে দিচ্ছি।
দিন মাই লর্ড কাইন্ডলি আমি দিচ্ছি না ওটা কোথা দিয়ে
এটা হলো রুল 15। রুল 15 হলোটা it relates to who is the pension sanctioning authority. First the rule 15.
আমাকে দাও ওটা কপিটা একটু দাও
Secretary.
Yes, that is the malota, the DI of school primary. He is the ex officio secretary. And the particular provision malota, that is 19.5, 19 subclause 5. 1 second, sorry. Malota 19 subclause 3. 19 subclause 3.
says cannot mean criminal field.
He will not be entitled to provisional pension. You have stated 18.2.
18.2 malot initially as per the court order, it was malota accorded to the petitioner, but it was only for 24 months, because the 24 months is the malota to which malot it can be extended. After 24 months it will be stopped as per the rule itself. 18.5 says 24 months is the outer limit.
18.5.
18.5. Sorry, my lord, 18.2. Kindly consider 18.2.
My lord, can I get a copy, my lord, just to hand
You
over,
get it.
so that
Yes.
I can also assist you, lord. আগের দিন পড়েছিলাম ভুলে গেছি তো
18 subclause 2. This is the outer limit, malota. The tenure of the provisional pension can be given.
The 18-1.
18-1. Yes, my lord, Department of Judicial Proceeding instituted and pending against anybody who is allowed to return on attaining age of superannuation or otherwise, he shall be paid provisional pension following his prayer during the period commencing from the date of his retirement to the date on which the final order are passed by appropriate authority on such proceeding. It is also there. And my lord, 18-2 says that provisional pension, the outer limit is for 24 months. In the event, my lord, the pension sanctioning authority is not able to processing his paper. 18-2. Now, my lord, the earlier round of litigation, the court had directed to take a decision over the my lord, petitioner entitlement considering his entire service career, my lord. On that basis, my lord, the authority had given the provisional pension only for 24 months.
No, in his case, this 24 months will apply or the 18-1 will apply?
My lord, in his case, my lord, subject to correction of your lordship, because it is there is a specific provision incorporated in the rule itself that criminal case, my lord, having a color of moral turpitude, then my lord, there is a specific provision. Then my lord, in that event, my lord, subject to correction of your lordship, the as the case involving my lord, immoral trafficking, it is very much having a moral turpitude color. My lord, then my lord, that particular provision, as per my understanding, my lord, it covers under that provision, because there is another similar, my lord, coordinate based decision. There is another this type of there is a criminal case pending and the court person got retired. In that particular, my lord, the court had directed that because the murder case was involved, the court had directed that you give him the interim allowance considering 19-3. That is, my lord, a criminal case pending having a color of moral turpitude.
And 1995 volume 6, you have referred on the earlier date. This is in respect of?
My lord, it is with regard to that. Here, my lord, the proposition that they have
24, I
projected.
have annexed the order.
Yes, proposition that was projected that a case, a criminal or the judicial proceeding, my lord, is having no connection with the my lord, service of the petitioner or having any my lord, financial my lord, misappropriation allegation is not there. In that event, if it is not there, then full pension should be paid. Now, the Honorable Supreme Court in this particular case has, my lord, negated that proposition, saying, no, in that when there is a judicial proceeding pending, the person will be, my lord, governed by the rule itself, and it is not necessary that it should always be related to a charge of, my lord, misappropriation or financial, my lord, financial, my lord, misappropriation. That is not required. Or the person is entitled only for the pension that the rule has actually given. Because in that Supreme Court decision, my lord, a issue of Prevention of Corruption Act was there. The authority has given him provisional pension.
Now, the order which I have annexed in page 24, my lord, in this order also, my lord, 19.5 has been, my lord, discussed, and considering the pending
তোমার DCRB 81
হ্যাঁ পরে এটা রুলটা হয়েছে না 2009
এটা এখন ওইটা আর গভর্ন হচ্ছে না এটা
প্রভিশনালটা কোনোভাবেই পাবে না প্রভিশনাল কোনোভাবেই পাবে না হবে
তাহলে ওটা if my lord wants to see the particular paragraph of that judgment of the Honorable Supreme Court where this issue has been dealt with, it is paragraph 6.
Paragraph 6.
Yes, because here the issue, my lord, the person is having a case pending under the Prevention of Corruption Act.
Yes.
Provisional pension was accorded. He approached the tribunal saying, no, full pension to be given to me because it not relates to my service. My lord, the Honorable Supreme Court, considering the CCS rule, those CCS rules is the mother rule. These are all, my lord, parameteria with the CCS rule. Considering that rule, my lord had categorically said, no, you are only entitled as per that rule on provisional pension and no full pension. Paragraph 6, the Honorable Supreme Court had clarified, even it is not relates to your any, my lord, financial misappropriation or pecuniary loss,
Relate to charges. Okay. So in his case, 19.3 will be applicable.
Applicable as per my, if Malot will, if Malot will don't want to refer any provision, let the authority be directed to consider the entire aspect of the DCRB and to take a decision with regard to his claim.
It is already there. After I come back, I will dictate the order.
2 p.m. I'm good.
First, Your Lordship, to accommodate me, because one matter will not fixed at court number 1 at 2 p.m. So my matter may kindly be taken up at 3 p.m. Because my
2:30 I will start with.
side is also here.
2:30 I will start with a part-heard matter which was going on yesterday.
Fine.
So I suppose there Mr. Sannal will argue.
That will
Thereafter, Mr. Vikas Ranjan Bhattacharya, then Mr. Abrutas Mujumdar, all are pressing their prayers for
time.
Otherwise, next week I can take it up.
Because today's instruction actually mislead us. Today's instruction was that from 10:30 pension matters would be taken up. So leaving other matters will not lead us to Your Lordship.
Anyway, you're 48.
48.
48, I'll take it up. What is the development?
My lord, development, I didn't, my lord, my learned friend is here.
My lord, the commissioner, the respondent number 2 has come up with his report, my lord, because your lordship was directed the respondent number 2 on the earlier occasion to calculate the retirement benefits.
That is with you.
No,
You
my
have
lord, I am for the respondent number 6. I am for the
No, Kolkata.
Council district.
Who is for the state? Commissioner for school education was directed.
Number 2 was directed
Commissioner was
to file
directed.
this report, my lord.
He has done so. Sure.
No, my lord, I have no
We have also no information of such, my lord.
You are carrying the
has
report.
come.
Yes. So give him a copy. Let us. You come back.
Copy of that report.
Next week এর রাখো।
Give me a copy next week.
একটা তো হয়ে গেল না 48 টা next week এর topic থাকবে।
Lordship, I am only making one pair. In the second half, my lord, I have some difficulty. My junior will be there to assist you.
My lord, in this matter, we have also sent our intimation letter to the commissioner, my lord. Kindly take it on record, my lord.
You keep it with him.
Yes, sir.
We take it up in the next week.
Okay.
Grateful.
Report filed by the Chairman, Malda District Primary School Council, dated 21st August 2026, is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for a release of pension and other pensioner benefits, as also arrear pension with statutory interest thereon. The petitioner contains that the petitioner was an assistant teacher of which school? Was an assistant teacher of
Assistant teacher under DPSC Malda. Make it DPSC Malda. I could not find the school name.
was an assistant teacher of a primary school under the District Primary School Council, Malda. The petitioner retired from service on superannuation on 31st January 2010. And during his service tenure, the petitioner was implicated in English Bazar Police Station case number 248 of 2007, dated 29 June 2007, under sections 3/4/5/6/7 of Immoral Traffic Prevention Act 1956. The petitioner was arrested in connection with the aforesaid criminal case. Since the petitioner was in custodial detention for more than 48 hours, he was suspended from service. The petitioner superannuated while on suspension. However, till date, the respondent authorities did not grant pension to the petitioner. Hence this writ petition. Para 3 same. Earlier order para 3 submission same. The addition করে দিন। On where is your representation? On
28th August
28th August 2025, the petitioner made a representation submitted a representation before the District Inspector of Schools. Respond number such and such, District Inspector of Schools P. Malda, for redressal of his grievance. However, no steps have been taken as yet. He seeks that the matter be relegated to the appropriate authority for taking a decision on the representation of the petitioner. Mr. Abhishek Prasad, learned advocate representing Malda District Primary School Council, submits that এটা দেবেন para 4, accepting এটা দেখে নিন, accept এইটা দেবেন না, এখান থেকে এটা দেবেন না, প্লেসিং থেকে বাদ। Be that as it may, since the authority is yet to take a decision on the representation of the petitioner, he submits that the matter be relegated to the appropriate authority. In view of the submissions advanced on behalf of the respective parties, the respond number such and such, District Inspector of Schools, 4 is directed to consider the representation of the petitioner dated 28th August 2025 and decide the same in accordance with law upon notice to the petitioner and pass a reasoned order. The reasoned order shall be communicated to the petitioner within a period of 6 weeks from date of communication of this order. The reasoned order shall be communicated within a week thereof. Then the advocate for the petition disposed of. 6 weeks and 1 week they will send the reasoned order. No. ওনারটা দাও, ওনারটা হচ্ছে 19893.
But I was sure it should be that's I'm citing today. Now, before that, if your losses kindly allow me the why I am citing this judgment. কি দেখা হচ্ছে না? হচ্ছে না এটা? এখন হয়ে গেল? Kindly take note of section 35. Section 35 of the Act. 35 of the Act of 2009.
Act is here.
যশোরে ওটা হ্যান্ডেল করতেই সুবিধা হবে।
Act is here.
Section 35.
35.
Power to issue directions.
Yes.
The central government may issue such guidelines to the appropriate government or, as the case may be, the local authority as it deems fit for the purpose of implementation of the provisions of this Act. Lord, if we consider this provision in the light of section Article 254 of the Constitution of India, if there is any repugnancy, Central Act will prevail. This is under the concurrent list, and this is a Pan-India Act. Now, therefore, your lordships, the Parliament reserves the right to the central government to issue all India basis, Pan-India basis, any direction to any state government or local authority. State government, why I am saying, your lordships, because appropriate government. Appropriate government means, my lord, your lordships will have the definition section. Your lordships will get it, my lord. So far, the school established by the central government, appropriate government, and relation to A. And in relation to within the territory of state, the state government.
Yes.
So, my lord, so far, my lord, there is no direction except the rules under the Act. There is no direction, my lord, of the central government in regard to section 25, except the Act itself.
Now, kindly consider my lord subsection 2. The appropriate government may issue guidelines and give such directions as it deem fit to the local authority or the school management committee regarding implementation of the provisions of this act. Why I'm citing it, Malad, I make it clear to your lordships. SOP has been said to be on affidavit, administrative instructions, executive instructions, language are this. I will stand corrected by your lordships if there is nothing. My lord, guidelines issued by maybe by the appropriate government, that means state government. My lord, at the cost of repetition, I'm saying there says under the memo of 10th July 2026, this was issued. Memo of 10th July 2026 issued by the my lord, Commissioner of School Education or Deputy Commissioner. I just take your lordships. Page. That your lordships issued by Commissioner of School Education. Now, my lord, Act gives the power to issue by the appropriate government. Appropriate government means, my lord, here state government. State government has not issued any guideline in the nature of administrative instructions, in the nature of executive instructions. Commissioner of School Education is not the state government.
Yes.
Now, my lord, for this proposition, I'm citing this judgment, 2009, 15 SCC, page 705, paragraph 42 and 43, right, 41 and 42. My lord, I read out these paragraphs, then because I'm citing this judgment on the basis for the ratio. 41, my lord, page 726, relevant page.
Reported.
Reported. 2009 15 SCC, page 705, paragraph 41 and 42. 705. Relevant page 726.
Page 726.
Or may I read out? The issue deserves to be considered from another angle. All executive actions of the government of India and the government of a state are required to be taken in the name of the president or the governor of the state concerned, as the case may be. Article 77(1) and 166(1). Orders and other instruments made and executed in the name of the president or the governor of state, as the case may be, are required to be authenticated in such a manner as may be specified in rules to be made by the president or the governor, as the case may be, Article 77 and 166(2). Article 77(3) lays down that the president shall make rules for more convenient transaction of the business of the government of India and for the allocation among ministers of the said business. Likewise, Article 166(3) lays down the governor shall make rules for more convenient transaction or the business of the more government of the state and for the allocation amongst the minister of the business, so far as it is not business with respect to which the governor is by or under this constitution required to act in this discussion. Constitution now. Section 166(2) says that it has to be in the name of the governor. If your losses kindly consider, and sub-rule 3, sub-article 3 is the procedure to be followed. Now, kindly your losses.
I have the bill. 166.3.
My lord, 166.2 first. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. Kindly see, my lord, sub-article 1, all executive actions, administrative instructions, they say, or executive action instructions of the governor state shall be expressed to be taken in the name of the governor. What I am trying to submit your lordships, I will place 42 also. Read with them, my lord, section 35. If any guideline or executive instructions or administrative instructions to be taken, that should be taken by the Honorable Governor in terms of section 35 of the Act, not by the Commissioner of School Education. He doesn't have any power, neither under the Constitution nor under the Act. Because the SOP says to carry out the purpose of the Act of 2009. Scope, they have mentioned it. Now kindly see your lordships, paragraph 42 of the judgment.
Just
That's why the discrepancies now appear before your lordships. 3 orders, 1 proposal, another executed.
Yes.
Kindly consider 42 paragraph of the judgment. This means that unless an order is expressed in the name of the president or the governor and is authenticated in the manner prescribed by the rules, the same cannot be treated as an order on behalf of the government. Now, if with this paragraph we read with section 35, kindly consider that section 5 says appropriate government may issue guidelines for the purpose of carrying out of the act. If I'm not wrong, your lordships, that's the provisions to the local authority for implementation of the provisions of the act. So, this is not an order of the government. It doesn't have any sanctity in law. They are forcing this order, hoisting this order to and upon the teachers.
Yes.
Now, I sum up just I sum up these 2 points. One is people-teacher ratio or another. I request your lordships to consider this because this is constitutional matter as per my perception. No, perception. Act, Central Act. We are all governed by this Act. Central Act doesn't conceive of any transfer of any teacher or deployment. Nowhere your lordships will find this expression except section 27 and subsection 2. That deployment, your lordships, for non-educational purposes. Census,
but
electricity duty.
In that event, the transfer rules will be redundant. If that
Obviously, to that extent, my lord. Transfer rule remain, but bereft of that. That's why, my lord, Rule 3 amended, though belatedly. I placed before your lordships, and Rule 4 be deleted and substituted by new one. Because of this reasoning, pupil-teacher ratio, for shortage of ratio, for deficiency in ratio, teacher should not be transferred because deficiency lies in the root of the matter. By transferring one teacher, the deficiency will not evaporate. This will remain. Kindly visualize your lordships. That's why this act has not conceived that, because it is for implementation of free and compulsory education at the elementary stage. This is the whole object of the act. Your lordships will find deployment twice, 27, and your lordships 20, subsection 2 of section 25, second part of it. Your lordships raised an issue. I tried to, according to my capability, to explain it. I will just remind your lordships my explanation to that. What is this? So therefore, this is not the scope of the act either, in a broader sense. And that's why two judgment of the Madras High Court and Kerala High Court was passed. That you are doing like this. Kindly your lordships come to paragraph, subsection 2 of section 25. Then I will make short submissions in respect to the other aspect. And এটাই তো বললাম আবারও ডেফিসিয়েন্সি থেকেই যাচ্ছে তুই বুঝলি কেন এটা র ল্যাঙ্গুয়েজে বলতে চাইছিস
একটা কথা চারবার করে বলা করা
two subsection 2 for the purpose of maintaining the pupil teacher ratio under subsection 1 no teacher posted in a school shall be made to serve in any other school. I request you lordship pause here for a moment and forget it that there is any other clause. Then what meaning will be ascribed to this? But according to my understanding, to maintain pupil teacher ratio, you cannot pick up one teacher and give it to another school, because both the schools are suffering. You cannot do that. The only remedy, your lordship, immediate recruitment of teachers in a wartime situation, because this is the object of the act. This is the primary education of the state or the country. And lordship, this is disjunctive. That's why I said deployed. Served, the word you served and deployed. বলে দিচ্ছি প্রচুর বাতিস আমি আর দেবো না
I just read again with you.
Yes, certainly. Kindly.
No teacher posted in a school shall be made to serve in any other school. You say this is one sentence. Then or office or deployed. Now
deployed.
For any non-educational purpose. Exactly. Is this for any non-educational purpose is going with deployed or other school or office or deployed for
only deployed, only non-educational purpose. According
that is what I'm on.
Because or disjunctive. Your lordship, deployment and to be posted to serve cannot go together. These are two different meaning, your lordships. Kindly visualize, your lordships.
Okay.
That's why section 27 given an exception.
Okay.
This is apart from all whatever I have submitted, this is an act, broad act. This is a broad, the entire object of this act.
Suppose all the teachers are, as per the sanction strength, all the teachers are there.
There is no need.
Then the rule of transfer will only be confined to medical.
No. I tell you, lordships. Kindly don't be. On its own motion, rule 3, rule 4A.
Yes.
I give an example to your lordships. Crude example I suffered in one case. 2 teachers found in a compromised situation in a school. Immediate requirement is transferred. That was done by this court. This is the situation where administrative necessity is there. Because of a particular teacher, there is a chaos in the school. Then transfer rule doesn't become OTOs. But only for the purpose of maintaining ratio, you cannot transfer teacher. Kindly visualize another, then I will come to this. 0 school, I have given you lordships 27 or 72, whatever may be the number. But if I put a question myself, why the school enrollment became 0? Because the government could not provide infrastructure to the school. No parent will send his child to a school where he doesn't have the education. That's why school became zero enrollment. This is a crude fact, my lord, truth. Otherwise, in our state, my lord, in our state or any country, so much of population, a school doesn't have students when the other schools are overcrowded. The reason is that infrastructure was lacking. And object of the act, first give infrastructure, including appointment of teacher, and then you proceed for recognition.
Okay.
This is the whole act, purpose of the act. Otherwise, teachers will be like a cattle. From this side, every year they has to go. They has to be transferred. This is not the object of the act.
Okay. Then come to Rule 3A, capital.
Our rules, state rules.
Transfer rules.
Transfer. I just. See, amended portion, yes.
Page 146 of your spiral binding.
146.
Yes.
Spiral. Oh, that's your loss. 3 capital. I got it. Three capital A.
And now it 3 capital A, proviso A, B, C, all is dealing with the PTR.
Kindly have a look at this. While considering transfer application.
My question is that the Central Act says that for the purpose of maintaining PTR, you cannot send a teacher as per your submission. He or she cannot be sent to other school for purpose of maintaining. Now the rule 3A says it has to mandatorily, the PTR has to be checked.
Why, my lord, I tell you, losses. Suppose I ask for mutual transfer, or my lord, I ask for transfer for my inconvenience on medical ground. Under Rule 3. Rule 3 are exceptional grounds your losses will find. While considering the transfer application under Sub-Rule 3. Sub-Rule 3 has given, my lord, the specific grounds. I apply for that to another district or to the same district in another subdivision. Well, my application will be considered. They have to see there will not be any excess or dearth of teacher. That's the object. That's for the purpose of maintaining 25(1). Not for transfer to maintain pupil-teacher ratio. You are transferring to maintain pupil-teacher ratio. And this is to effect transfer, you have to see first that the teacher-pupil ratio is not affected. Am I correctly put at your losses? This is the case.
So as per you, transfer is not the answer to deficit.
Exactly, man.
Okay.
It cannot be. And I have given the calculation so far district is concerned.
Okay. That's all.
This Malad do only 2 things, Malad. I just Malad without opening the brief. Malad, they have said in Malad under the rules, Rule 10 is there. If you are aggrieved by transfer order, go for appeal. Malad, most misplaced submission, because I have come up before your lawsuit for a constitutional law. Implementation of the constitutional provisions and the act made there under Article 21A. But I'm questioning the very declaration of the act, the act of surplus and deficiency. This is wrong. I cannot go to the transfer authority and say that this question cannot be decided. Then SOP kindly see the revised for determination of surplus teacher by way of biological age. Where form you are getting it? This goes to the constitution, completely unconstitutional.
Okay.
So this cannot be decided by the appellate authority for transfer. This has to be considered by the constitutional court.
Okay.
This is one thing, your lordships. And I tell your lordships, this the point of Dama, all of we have paid the court fees. I think your lordships, yesterday I pointed out also what more juror relationship can be. Because by a common order, everyone is being affected. All teachers. All teachers are being affected by common so-called SOP. আরেকটা যে জাজমেন্ট দিয়েছে ওটা দেখো। এটা কাল দেখাচ্ছি। দেখি দেখেন দেখেন দেখাচ্ছি না। তাহলে আমি ছেড়ে দিই বিকাশ দা বল বিকাশ দা চলে আসছেন আর কি বলবো যথেষ্ট হ্যাঁ রিপ্লাই তো দিতেই হবে সে তো রাইজ এটা বলার কি আছে therefore malad the SOP should be quashed and all actions they are under should go malad everything should go these are my humble submissions malad problem Mr. Tijari will make
দাও এই দেবনাথ বাবু ওটা দিন ওই কি বলে অ্যাফিডেভিট অপোজিশন দিন আর উনি আর্গু করবেন এটা রাখো এগুলো না আমি পিটিশনের নাম্বার দিয়ে দিচ্ছি উনি প্রবাবলি আর্গু করবেন যাতে এটা ছিল লিস্টটা ছিল বলো নাইন ফার্স্টটা যেটা
বন্ধ করেছি ঠিক আছে
ওই তো 19417 6 ঠিক আছে ইয়েস এই ওনাকে বলো সেখানে সামনে ঘুমোতে না
Hey, ঘুমোচ্ছি কন্টেন্ট যা
Mr. Bhattacharya, you are arguing 19417.
Yes.
Oh.
Well, I'll be very brief.
Yes.
Since Mr. Shanial has made an exhaustive argument. Lordship probably has been taken through the RT Act. I will just take two sections. It was also placed still for my satisfaction. Kindly come to section 25 of RT Act.
25. Yes.
Now, within 3 years from the date of commencement of this act, the appropriate government and the local authority shall ensure that people-teacher ratio as specified in the schedule is maintained in each school. It's very important. And then says, for the purpose of maintaining the PTR under subsection 1, no teacher posted in a school shall be made to serve in any other school. That means that you have to strictly maintain the pupils-teacher ratio. While somebody is engaged in a school for the purpose of maintaining of ratio, he cannot again be asked to discharge in another school. That is to ensure that PTR is maintained. And now how PTR is to be maintained, Lordship can now turn to the rules. And then I shall take a Lordship to the SOP and conclude.
Which rules he is referring to transfer rules?
Just handing over a copy. RT rules.
RT rules.
RT rules.
It is not there?
Hatibaji করেছিস This might be not appears to be little in difference with the submission of Mr. Shanial, but I'm placing it below, it's my duty. Rule 22, maintaining people-teacher ratio. the sanction strength of teachers. Therefore, the primary duty is to have a sanction strength assessed by the appropriate government or the local authority. In our school, shall be notified by the central government, appropriate government or the local authority as the case may be, within a period of 3 months of the appointed date. And then says, provided that the central government, appropriate government or the local authority as the case may be, shall within 3 months of such notification redeploy teachers. Now the transfer word was categorically avoided because authority thought this is deployment, not really transfer. The teachers are not discharging the same duty. Shall be redeployed teachers of schools having strength in excess of the sanction strength prior to the notification. The once notification is declared, the strengths are not quantified. You have to maintain that. And if you find that some teachers are in excess before to the notification, then you can redeploy them. But taking here, the government might argue that if the provision of redeployment was contemplated by the parliament, if it was possible for prior to notification, sanction declaration, what's the bar if it is done later? No bar. Bar is you have to ensure that the sanction strength vis-a-vis PTR is maintained definitely. Therefore, we have to see that where is the notification declaring the sanction strength in a particular school. Unless that is declared, you cannot come to PTR. So once that is declared, then you have this strength of teachers as per the schedule. Schedule is also there. I believe it has been placed. And then you can redeploy. Now then the question would come, how to redeploy? What would be the foundational principle of redeployment? Is it whims? Or is it based on some rational principle? Now, taking to that, if a lordship kindly takes up the SOP, which they have filed in terms of my lord's direction, I will show my lord that there was some rationality while deciding, but thereafter maybe under somebody's advice there has been departure. Definitely not on Mr. Piyush.
Page 49.
No, the affidavit. No, sorry, this is the affidavit. Affidavit on behalf of the state respondent.
The affidavit in opposition to? The affidavit in opposition to? It is the reply.
It affidavit opposition affirmed by Mr. Amol Kumar Shil. Amol Kumar Shil.
Yes.
Now that some comments are to be made, kindly come to paragraph 8. With a view to rationalizing the deployment of teaching staff in the government-sponsored aided primary schools across the state, and to identify surplus teachers posted in zero enrollment school. How could it be possible after the RT Act, the schools having zero enrollment? Now, to avoid your basic responsibility to bring the students to the school for education, you are encouraging zero employment school, a zero enrollment school. Thereby, your tendency is to close down the school. And the teachers who are there, now you want to redeploy them. Well, I am not in at all adverse to the concept of redeployment, transfer, whatever you might say. But is it keeping in mind that to ensure the failure on the part of the authorities to bring the student to school, you want to drop the school? We have to think from that aspect, because the RT Act, the Lordship has been pleased to go through a number of times, is only for the purpose of ensuring complete elevation of illiteracy. That's why RT Act, which was the obligation on the directive principles of state policy. Now, instead of encouraging the students to come to the school, you want the schools to go. This is my concern I am placing before the Honorable Court. And then say genuinely in need of teachers consistently with the mandate of maintaining prescribed pupil-teacher ratio under Section 25. Now you undertake the provisions of Section 25, leaving aside all other mandatory obligation of the RT Act. I'm sure the state will consider whether this would be the appropriate one. At the same time, I say that you cannot keep a teacher waiting in a zero enrollment school. But what is your attempt to ensure that enrollment increases? Unfortunately, my lord, in the recent times, the last 10, 15 years, my lord, the primary school going children, my lord, are not going to school. Why? That is one aspect. Then, subsequent to paragraph 9, SOP for identification and transfer of surplus teachers from zero enrollment schools and the rationalization of deployment of staff in its unmodified form was communicated so and so, so and so and so. Then provided, next page, my lord, for identification of the teacher to be treated as surplus on the criteria of seniority by date of joining. Now, this was the rational perception of the whole thing for redeployment. Now, subsequently, I find, I don't want to take your lordship, Lord, to waste my precious time, they have changed it. Changes to an irrational principle that the surplus teacher would be determined on the date of birth. But which is, lordship had a lot of experience presiding over the industrial benches, I know. Therefore, when you decide to deploy surplus teacher, surplus would be the person who joined last. Principally, last come, first go. And that was the initial perception. The identification of the teacher to be treated as surplus on the criteria of seniority by date of joining.
Yes. Yes.
Subject to the, by just read once again, provided for identification of the teacher to be treated as surplus on the criteria of seniority by date of joining, subject to the option of any willing senior teacher to offer himself, herself, surplus in lieu of such teacher. Therefore, again, the assertion is that that principle should be followed, but if anybody is willing to, that's a different thing. That's a volition. Thereafter, upon the said SOP being revised by the competent authority inter alia by replacing the criteria of seniority under clause so and so with criteria of biological age while retaining the option of any willing teacher. I mean, like, what is the rationality? When you change, you must have some reasons behind it. It's nothing disclosed. Therefore, rationality of fixing up the surplus teachers is given a go by. Why? We do not know. Let me further proceed to show. The modified SOP was communicated afresh to all district primary school councils by email dated such and such, issued from the office of the Deputy Director of School Education with a clear advice and direction that modified SOP for all purpose, to use the modified SOP for all purposes. Therefore, they are insisting that it should be on biological age, not on seniority in terms of recruitment. Well, that has to go.
Yes.
Then another aspect I would point out to your lordship, Lord. Paragraph 10, it is respectfully submitted and reiterated at the outset that the petitioner sought to project as fast SOP as opposed to a revised SOP are not two independent, competing or contradictory instruments issued simultaneously. As already stated in paragraph 8 and 9, the memo dated 10th of July 26 did not itself enclose any SOP. The SOP was first communicated in its unmodified form only by email dated so and so with a request to contact the deputy director in case any doubt and not to share the SOP with anyone. Well, why this hide and seek game? What's the difficulty in sharing the SOPs? I don't know what played in their mind. Modified by so and so with a clear advice to use modified as all purpose. There is and has at all material times since 27 July been only one operative SOP for rationalization, namely the SOP as modified and communicated by email dated 27 July. All district primary schools should advised and continue to be advised to act only upon in terms of the said modified SOP. But here is the specific grievance and basic grievance. Well, I do not challenge the authority of the government to determine people's teacher ratio. But where is the notification notifying that this is the sanctioned strength of a school? That has to be found out. I don't find subject to whatever he clarifies later. Because excess teacher would depend on the notified vacancies. Two,
Yes.
by encouraging teachers to be declared as surplus in the zero enrollment school, you are betraying the confidence of the RT Act. That has also to be looked into. They have to justify before your lordship, since my lord is really presiding over this bench, that how far they are going to implement RT Act. Now this has, again I say, my lord, I do not confuse it with the PTR. But I say the PTR also has a foundation. That foundation is increase the enrollment. If you remove a teacher, then nobody will come. Would that really fulfill the purpose of the act? These are the 2 points that I acknowledge your lordship. Therefore, when you are exercising a particular provision, you have to keep in mind that the other principal purpose of the act is to ensure complete free education. That has to be not ensured. Before deciding to declare a teacher surplus from zero enrollment, the attempt should be made to enhance the enrollment. And on the principle,
Yes.
now, my lord, on the principle that last come first go is the rational principle, my lord, I don't think I should cite any authority to your lordship. Still, then my junior insist upon, my lord. This is 1960. Yeah, 1960 Supreme Court, page 762, corresponding to 1961 Labor Law Journal, page 504. This is also available in online. Joshua Gunta. The 3 judges bench. That paragraph 4. The tribunal held that the strike declared by the respondent was not justified and that the appellant was justified in retrenching 39 workmen in question. According to the tribunal, though in retrenching 39 workmen, the principle of last come, first go was not strictly followed, the appellant was justified in departing from the said principle because it was entitled to give preference to persons mechanically inclined and having good eyesight. I'm citing, Lord, I've just heard a murmuring that the government thinks a young person have a better legwork. That cannot be a ground. That When this judgment went up to the Honorable Supreme Court said, no, you can't do this.
Yes.
In paragraph 10, in support of his contention that the Labour Appellate Tribunal has exceeded its jurisdiction in examining the merits of the retrenchment effected by the appellant, the learned Attorney General relied upon certain observations made by this court in the case of J.K. Iron so and so, dealing with the argument of the appellant that the order of retrenchment should be left to the management and that the decision by the management that some employees are better qualified than others should not be questioned by the adjudicator unless he came to conclusion that the preferential treatment was deemed to be mala fide. This court observed that the proposition involved in the argument was unexceptionable. It was added that if the preferential treatment given to juniors ignores the well-recognized principle of industrial law of first come, last go, without any acceptable or sound reasoning, a tribunal or an adjudicator will be well justified to hold that the action of the management is not bona fide. Then Lord gives the reasoning. I am not troubling my lord with that. Therefore, the basic principle of last come, first go ought to have been, my lord, adhered to, and that should be adhered to. Well, these are my submissions. I'm deeply obliged. Well, may I take leave? Okay. What? Huh? What?
Next আরো আইটেম আছে না আর দুটো আছে না না ওয়ান তিনটে আছে
I'm so sorry, madam. Kindly pardon. Kindly give me 1 minute.
তিনটে হবে তিনটে
Yes.
19720 করবে 19857
I will only make submissions. I'm sorry.
There are 3 writ petitions which you will argue.
I am arguing 19903. 19903.
What about 19720 and 19857?
That I am not aware, my lord. I think Mr. Bishas.
And 19903, I am opposing.
Okay.
Oh, Mr. Ahmed, Shamim Ahmed is
Where is he?
He is physically indisposed of, I am told. Oh, he's on his way. After I conclude, he will take over.
Okay, 19720.
19903.
No, Mr. Ahmed is appearing in 197.
একটাতেই করছে শামিম.
Oh, yes.
Mr. Dasgupta is appearing in one minute. May I take your lordship?
এটা 19 এটা দাও 19903. এটা ওটার সাথে রাখো. Yes.
Most of the points have been covered by Mr. Sannal, so I will not repeat. I take your lordship to the affidavit in opposition filed on behalf of the state respondents.
Opposition copy.
This has been affirmed by Shri Amar Kumar Shil, who is my lord, the Assistant Director of School Education.
Yes.
Will kindly take paragraph 9 of the opposition. That subsequently the SOP for identification and transfer of surplus teachers from zero enrollment schools and rationalization of deployment of staff in its unmodified form was communicated by email dated 11/7/26 to all district primary school councils, and sub-inspector of schools, and with a request, just a minute. With a request to, yes, with a request to contact the deputy director rural so and so in case of any doubt, and not to share the SOP with anyone. So my lord, when the SOP was in its initial, the initial avatar of SOP, they were not ready to even share the SOP for, my lord, for the public at large, at least the affected parties. So everything was done in a hush-hush manner initially. Then, my lord, the clause 70 of the SOP, as so communicated on 11/7/26, provided for identification of the teacher to be treated as surplus on the criterion of seniority by date of joining, subject to the opinion of any willing senior teacher, offer himself or herself as surplus in lieu of such teacher. Thereafter, upon the said SOP being revised by the competent authority, inter alia by replacing the criterion of seniority under clause 7D with the criterion of biological age, while retaining the option of any willing senior teacher to offer himself or herself as surplus, the modified SOP was communicated afresh to all district primary school councils by email dated 27/7/26, issued from the Office of Deputy Director of School Education, Rural Primary, West Bengal, with clear advice and direction to use the said modified SOP for all purposes. It is also placed on record that the same modified SOP was thereafter circulated at the field level under the copy of local office number so and so. Kindly take, my lord, the annexure R2.
May I take, my lord, short leave, my lord?
Yes. R2, page number
49. My lord, I will start from a little. Kindly take from page 47. My lord, the any order of transfer would have some consequences for the employee. And my lord, how the state proceeds in this matter. Kindly take page 47, which is an email from Deputy Director Rural Primary to all the DPSCs. Your lordship has got that? All the DPSCs. In continuation to the memo dated so and so, dated 10 July 2026, which was sent through email on yesterday, as per direction of higher authority, a SOP which is annexed hereby sent to you for doing the work of for nationalization. The chairman or chairperson is requested not to share this email or SOP to any other. If there is any doubt, please contact DDRP, that is Deputy Director Rural Primary. So, my lord, the approach is something very opaque. The approach is not in conformity with, my lord, the transparency, policy of transparency, which is required to be observed by any state authority. This is the instance one. Now comes the next one. Kindly take page 47, capital A. This is again same. Kindly take, my lord, page 40. This is 48. This is again addressed to all the DPSCs. So all the DIs. Sorry, DI primary education. Well, kindly take the content of the mail as per direction of the higher authority. My lord, the identity of the higher authority is not disclosed. As per direction of the higher authority, please follow the modified SOP for rationalization, which is annexed herewith. Well, kindly take the SOP which was sought to be modified. Now I am using the expression sought to be modified. Why I am doing so would be evident from page 49. . 49 . 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. 49. Kindly take, my lord, page 49. My lord, may I just take your lordship through identification of staff for transfer? My lord has got that particular portion.
Yes.
Roman 7. After D, for consideration of surplus teachers, for consideration, D reads thus: for consideration of surplus teachers, senior teachers in respect of the date of joining in the present school shall be considered first for. It is pertinent to mention that there is no such provision in the existing rules. May be replaced by the following. So, my lord, this is a memo which was in the formative stage, because it may be replaced. So there is a discussion which is going on, or there is some kind of deliberation which is going on at the level of different officers of the government, that this may be replaced. What is then circulated is, my lord, a post replacement revised SOP. The counter affidavit filed by the state authorities does not disclose the date of the first SOP, if I use the term first and second, the date on which, my lord, this first SOP was it was decided that it requires reconsideration, the date on which the state government authority decided, yes, upon reconsideration, now the present revised SOP should read like this. And this is part of their affidavit. So whatever they have annexed as annexure R2, this is revised. This is not revised SOP. This is a revised SOP in the making. It's a work in progress. It cannot acquire. It is not, my lord, given some final character. It is just like a file noting that you may replace this with that. So, my lord, my case before your lordship is first that we have, as per the pleadings in the affidavit in opposition, we have one SOP, one revised SOP, WIP. I use the term WIP because it's a work in progress. And those are undated, unsigned, unauthenticated. I have taken this point in my reply specifically. And I'm grateful to the state government for at least disclosing the true state of affairs in the affidavit in opposition. My lord, now, regarding this parent-teacher ratio, my lord, I have made my submissions in my affidavit in reply, but I am not going to repeat because I would be repeating the submissions of Mr. Sannal. My lord, your lordship's time is very precious. I will not do so. Now, my lord, kindly come back to my primary contention, which I raised at the stage when this matter was moved. It was my contention, which was at that stage not answered to, and not even answered to at the stage of filing counter affidavit, that this policy, they say that this is policy. Obviously, if this is policy, this is a government policy. Obviously, if this is a government policy, my lord, it has to be made in terms of Article 162, read with Article 166(3) of the Constitution. The policy, the SOP, which is not dated, not signed, not authenticated, cannot be said to be a policy in terms of Article 162, read with Article 166(3) of the Constitution. My lord, I also say why this policy is opaque, and this policy is an unworkable policy. Why this policy is an unworkable policy? Well, I have given, my lord, indicia for that, which is there at page 4 and 5 of my affidavit. May I just give your lordship the indications? The first indication is that the SOP does not disclose the manner in which the teachers would be declared as surplus in the primary schools. The SOP number 2, the SOP does not also disclose as to whether there would be any public announcement or declaration regarding deficit staff strength in the primary schools within the districts.
Number 3, but this is the primary exercise for effecting rationalization. Number 3, the number of teachers that have been identified as surplus, the manner in which option is to be exercised by the willing teachers.
Yes.
Number 4, the manner in which the willing teachers are to be accommodated according to their request, having regard to the alleged deficiency in staff strength. Number 5, the SOP does not even disclose the publication of the pool, but there has to be a pool of available teachers. That is not even disclosed. Number 6, this is very crucial. The head teachers in respective primary schools are included for the purpose of counting the surplus as per SOP. However, the SOP does not provide for transfer of head teachers. If it is decided, I will not invite your lordship to sit over the wisdom of the policy makers, so-called policy makers, if it is at all policy, which they have failed to prove so. If it is decided to exclude the head teacher from transfer policy, in that even the head teacher cannot be included for the purpose of counting surplus teachers. A school may have 4 teachers and 1 head teacher. While the counting is made that these are the excess teachers, these are the surplus strength. When the head teacher is not to be considered for the purpose of transfer, the head teacher should not be counted for, my lord, arriving at the figure of excess teacher or surplus staff. Number 7, there is no provision in the SOP for publication of names of teachers who have willingly opted for transfer and the list of opted schools. Not given. Number 5, this is very important. Kindly take rule 4 of the primary teachers rules, which is annexed to my writ petition, in fact. Just give me 1 second. It is at page 50. So lordship kindly takes conditions for transfer.
Yes.
My lord, there are 2 ways or 2 methods by which transfer could be made. Either the council may on its own motion or on an application by the teacher. My lord, once, as indicated in the emails which I read out to your lordship, that as directed by the higher authority, the exact expression used in the email is higher authority. This has to be followed. Then, my lord, whatever consideration the council would have to make, that would be, my lord, basically acting as per the diktat of the order of the SOP. No room for discretion is left to the DPSCs, respective DPSCs, to work a process in terms of rule 4 of the these transfer rules 2002 as amended. Then, my lord, it is very important. My lord, I believe submissions have been made with regard to biological age, the discrimination based on biological age. Well, I have another take on that. It's a different take. Kindly take rule 6 of the transfer rules, which is at page 52. Kindly take, my lord, page 52. May I just read out? There's only one first sub-rule will do of my writ petition.
Yes.
Bar to transfer. No teacher shall be eligible to apply for transfer for a period to 5 years from the date of transfer. Kindly take sub-rule 2. no teacher shall be eligible for transfer if he attains the age of 57 years. My lord has got that? So, my lord, transfer on the basis of biological age is provided for in the rules, and that's a standalone provision. If it is a standalone provision, so far as transfer on the basis of biological age, no further addition could be made by way of SOP. This is the only provision made in the rules so far as transfer on biological age is concerned. Malad, having regard to such provision of law, it is my submission before your lordship that the principle or the maxim expressio unius est exclusio ulterius would be squarely applicable here, because only one category of teachers had been picked up who need not be transferred as per the rules. The SOP speaks contrary to the rules. It carves out another category of teachers based on biological age. Your lordship will find when the discussions are made in this revised SOP in making, they say that we cannot introduce a provision which is contrary to rules. So they are conscious of the fact that any provision which is made in the SOP is contrary to the rules, that provision cannot be included in the SOP. Now, my lord, when a specific provision has been provided for regarding transfer on the basis of biological age, and that is the only and only provision in the statute, then I put the question to myself with all humility, no further addition could be made by way of SOP. Otherwise, the rules have to be amended. Yes, they can do so. I am not saying that they cannot do. In their own wisdom, they can amend the rules. They can do so, but not in this manner. Now, Milord, now coming back to their AO, the affidavit of opposition. Kindly take, my lord, paragraph 19 of the AO, page 32. Ground 1, source of power.
Page 19.
No, sir, no, my lord, it is para 19, page 32.
Yes.
Source of power applicable in so and so. That memo, number so and so, and the SOP frame thereunder are administrative and executive instructions issued in aid of and for effective implementation of the statutory mandate under section 25 laid with schedule to the RTE Act 2009, maintenance of people-teacher ratio, and more particularly of the power of transfer already expressly vested in the council under Rule 4 of West Bengal Primary Education Rules. It is submitted. এটা তো তোদের এফিডেভিট প্যারাগ্রাফ 19 একই তো সবকটা প্যারাগ্রাফ। It is submitted that Rule 4A of the rules expressly empowers the council. They refer to Rule 4A, but they do not refer to the condition provided for in Rule 4A. The council has to act on its own motion, not as per the diktat of my lord higher authority. So they say it is provided yes, in its approved teacher expressly empowers the council to transfer an approved teacher within its jurisdiction on its own motion without any application from any teacher concerned. And the further proviso to Rule 4A expressly empowers the council where there is surplus teacher according to role strength as stated in Rule 3 to transfer such teacher on its own motion and without maintaining a time limit of service by a rational adjustment of teachers in a primary school having a deficit of teachers in the order of preference set out therein. Rule 4B is also taken recourse to at least inconvenience caused to the so as to cause least inconvenience to the teacher concerned. the very concept of surplus teacher identified by roll strength and enrollment and of a rational adjustment of such a teacher to a deficit school, which lie at the heart of the impugned memo and SOP, are thus not novel executive creations, but find express and statutory anchor in Rule 4 of the Transfer Rules 2002 itself. I pause here for a moment. Kindly take Rule 4. Rule 4 does Rule 4, in my most respectful submission, put the question to myself, empower the state to formulate an SOP for transfer in terms of Rule 4? In my humble understanding, whatever I could understand, the answer would be in the negative. It doesn't say so. It does not involve the state government or its officials so far as transfer of teachers is concerned. The authority is clearly vested with the council.
Yes.
So, their only statutory anchor, I may use the expression which they have used, anchor is Rule 4, and Rule 4 is definitely, in my understanding, is not an anchor for this SOP. And I'm also grateful that they refer to Rule 4, they recognize that though this particular SOP has been given the nomenclature of rationalization of the staff structure or staff strength, etc., but actually it is a comprehensive module for transfer. It is a comprehensive module for transfer. And so far as this SOP is concerned, for the reasons, for the factors that I mentioned, submitted just prior to these submissions, the SOP does not contain discernible adequate guideline so as to, my lord, implement the rationalization policy, because I've given the relevant points, that these points are clearly missing in the SOP. Now, my lord, I take your lordship to the fact, since this is their only case, kindly take, my lord, the judgment, some of the judgments, one I placed and another one I will try and place right now. The first one that I placed before your lordship at the initial stage was Bhurinath versus State of Jammu and Kashmir, 1997 to SCC 745. My lord, kindly take Bhurinath. Your lordship will kindly take. My lord, I think I have handed up a copy. If we have other copies available.
No, it is there.
It is there. Well, I will just take your lordship once again through. Oh, today? ঠিকই আছে স্টেট কত ছাপাবে জানে বলে তাই kindly take, my lord, Bhurinath, paragraph 19. By operation of Article 154, the executive power of the state shall be vested in the governor and shall be exercised by him, either directly or through officers subordinate to him in accordance with the Constitution. By operation of Article 162, subject to the provisions of the Constitution, the executive power of the state shall extend to all matters with respect to which the legislature of the state has powers to make the law. Thus, except his discretionary power like that of appointing chief minister, governor, the governor does not exercise any power in his individual discretion. The governor is aided and advised by the council of ministers appointed by him under Article 163. The executive power of the state is coextensive with that of the legislative power of the state, and the governor, in the constitutional sense, discharges the functions under the Constitution with the aid and advice of the council of ministers, except in so far he is by or under the Constitution required to exercise his functions in his discretion. Malad, this is the second sentence is not applicable because it was subject to the limitations as imposed under Article 373. Article 373 is now done away with. So we are not concerned. Next part. All the executive actions of the state government shall be expressed to be taken in the name of the governor. And as per business rules of the government made in accordance with Article 166 of the Constitution and the business rules made by the governor under Clause 3, Section 40, so and so. In summarizing, a bench of 7 judges of this court held that under the cabinet system of government as embodied in our constitution, the governor is the formal head of the state. He exercises all his powers and functions conferred on him by or under the constitution with the aid and advice of his council of ministers, save in spheres that the governor is required by or under the constitution to exercise functions in his discretion. So, the real power, the executive power, has to be exercised in terms of Article 162. Yes, my lord, the power is coextensive with the legislative power of state. There is no doubt about it. But here, what we find, here there is an act, there are rules made under the act, and my lord, these rules have not been amended. And these particular SOP, whether the first SOP or the second SOP in the making, it does not say in any way that who has authenticated it, who has issued it, who has put this, who has signed it. Nobody is taking, the responsibility for the SOP. It says that it has been circulated by the school education department. That's it. Now, coming back to the source of power, that heading. Kindly take page 33, just above ground 20, paragraph 20. The memo, dear Lordship has got?
Yes.
I'm starting from this last sentence at paragraph 32 and continuing with this paragraph 19. The memo and SOPR do no more than lay down the internal procedure, sequencing and objective criteria for the uniform statewide exercise for this pre-existing statutory power. So statutory power, they are referring to Rule 4, which is not so. And do not purport to be and need not be notified as subordinate legislation under 106 or 107 of the Act of 73. Well, kindly take the Act. So admittedly, this SOP is not a subordinate legislation. The SOP, well, Lordship has got this Primary Education Act.
This is volume 1?
Yes, volume 1. This one, volume 1.
This is education manual?
Yes, my education manual.
Page number?
I'm giving your Lordship the exact page. Kindly take first page 89. This is the power of state government to make rules.
Yes.
Well, the rules which have been made for transfer of teachers has been made in exercise of the power conferred under section 106. Now, kindly take sub-rule 3. Subsection 3, I'm so sorry. Subsection 3, this is very important. All rules made under this act shall be laid for not less than 14 days before the state legislature, as soon as possible after they are made, and shall be subject to such modification as the state legislature may make during the session in which they are so laid. Any modification of the said rules made by the state legislature shall be published in the official gazette, and shall, unless some later date is appointed by the state government, come into the force on the date of such publication. So, any rules, even the transfer rules of 2002 or the amendment to transfer rules of 2002, they had to cross the floor of legislature. There are two kinds of laying, your Lordship has obviously noted in several matters. One is simple laying, that the rules and regulations are laid before the legislature, but there is no power of modification given to the state legislature. There is another class of rules or regulations which are to be laid before the state legislature, but those rules and regulations may be subject to modification by the state legislature. So in this second class of rules or regulation, it is a case of legislative affirmation. So I make this submission before the Lordship with all humility. Transfer Rules 2002, which has been legislatively affirmed in terms of section 107 subsection 3, can it be modified, tinkered with by way of an SOP, which is not even authenticated, not even signed, not even dated? This is not a simple laying procedure. This is a laying procedure where the regulations or rules are subject to modification. Along with this, kindly take, they say that no, this is also not an order in terms of section 107. Kindly take, section 107. They clearly say in their affidavit that this particular SOP has not been issued in terms of rule section 106 or 107. May I read it out, my lord?
Yes.
Power of state government to issue notification or order in place of making rules. Well, it is like, my lord, your lordship will find in several acts, your lordship have definitely dealt with those acts. There is a power given to remove difficulties. That there is no law, there is no rules, there is so government is given the power to remove the difficulty by issuing an order. So this is a kind, notwithstanding anything contained in section 106 or elsewhere in this act, the state government may issue notification or order for carrying out any of the purposes of this act for which that government does not consider it necessary to make rules. So, my lord, it may be a subject with respect to which the state government can make an order or can issue a direction or can issue a notification where there is no necessity of making rules, A, or issue notification order not inconsistent with the provisions of this act in place of making rules under this act if that government considers it necessary to do. So, there are two circumstances. One, rule making power is not required to be exercised. Number two, this government decides that instead of rule, I'll issue this notification. So 106 they say we have not exercised. 107 they say we have not exercised. So whatever statutory power is provided for in the Primary Education Act,
yes,
that statutory power has not been exercised admittedly. So this is this SOP. What should I say? I'm constrained to make this submission. This SOP, is a kind of a I won't even use that word, a government document. It's a kind of executive fancy. It's a flight of fancy of the executive government. And it is merely an executive fire without any statutory backing. Next judgment I would like to place in this connection would be 2018 8 SCC 215. Hey, এটা copy needed.
2000 আগে যায়নি
If I repeat something which Mr. Sharnal had submitted, kindly, my lord, stop me. But I don't want to waste your lordship's time. Paragraph 39 of this 2018 8 SCC 215. Kindly take, my lord, this is a quotation from Shanti Sports. In Shanti Sports, a bench of 2 judges of this court. Sorry, what? 2018 8 SCC 215. এইটা কত তো সব কই পাঠিয়ে দিচ্ছি এটা করে 8 SCC page 215. Paragraph 43 is from the quotation. A noting recorded in the file. I'm sorry, my lord, I should have waited. I'm sorry.
43.
Para 43. My lord, it is para 39. My lord, it is quoted para 43. 39 quote Shanti Sports, and the quoted portion I am just, my lord, placing before your lordship. My lord has got the quoted portion.
Yes.
A noting recorded in the file is merely a noting simpliciter. Pausing here for a moment, my lord. The annexure at page 48-49, as I made the submission before your lordship, was at the stage of, my lord, deliberation. Maybe replaced, maybe replaced. So that is akin to a administrative, akin to a product of administrative discussion, not the final product. But it is an intermediate stage to the final product. Today we do not know if the state says that this is the final product, then whatever has been circulated and whatever has been challenged, that's not the final product at all. State says that this is the final product, and according to me, in my reading, that it cannot be the final product because it says may be replaced, not substituted. And whatever is circulated to all the DPSCs, what we have challenged, the second SOP or revised SOP, that is including that substituted portion. But the affidavit does not say that when the substitution took place, because they have annexed only, the proposal for substitution. Page 48 and 49 is nothing but proposal for substitution. So I'm making this submission for twin purpose, that any executive decision, any intermediate product is not, cannot be the basis of any executive action. A noting recorded in the file is merely a noting simpliciter and nothing more. It merely represents the expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. So, this noting, this annexure at page 48-49, even if they claim that this is a deliberative product of deliberative process, this cannot be treated as a decision of the government. The same, yes, even if the competent authority accords opinion in the file on the merits of the matter under consideration, the same cannot be termed as a decision of the government unless it is sanctified and acted upon by issuing, this is where I'm on, by issuing an order in accordance with 77(1) and clause 1 and article 77 clause 2 and or articles 166(1) and article 166(2). The noting in the file or even a decision gets culminated into an order affecting the rights of parties only when it is expressed in the name of the president or governor, as the case may be, and authenticated in the manner provided in article 77(2) or article 166(2). A noting or even a decision recorded in the file can always be reviewed, reversed, overruled, or overturned, and the court cannot take cognizance of the earlier noting or decision for exercise of the power of judicial review. So, your lordship can certainly strike down this kind of noting. Lordship can even strike down the proposal. And this is Supreme Court, my lord. Your lordships, my lord, your lordships are also held in similar lines. Now, my lord, I come to the last portion. My lord, I believe, my lord, during the course of hearing, your lordship was pleased to express a view regarding the interplay between section 25 and 27 of the RTE Act, subject to correction. Madam, may I make my respectful submissions before lordship for the lordship's kind consideration? How these two provisions I read, my lord. Obviously, my lord, your lordship would be the final to decide. RTE Act. Kindly take section 25. What is it? For rules. No, এটা তো act. এটা act, ঠিক আছে. Yes. 25. Kindly take, I not trouble your lordship with the entirety of the provision. Section 25, subsection 2.
Yes.
For the purpose of maintaining the pupil-teacher ratio under subsection 1, no teacher posted in a school shall be made to serve in any other school or office or deployed for any non-educational purpose other than those specified in section 27. If I have correctly understood, my lord, your lordship, I will stand corrected, my lord. Your lordship is of the view that this section 27 will control the entirety of subsection 2. Have I correctly understood, my that? If I have correctly understood, your lordship is of the same view. Now, kindly take section 27. prohibition of deployment of teachers for non-education purposes, educational purposes. No teacher shall be deployed for any non-educational purposes other than decennial population census, disaster relief duties, or duties relating to elections to the local authority or the state legislatures or parliament, as the case may be. Now, I would once again take your lordship to subsection 2.
Yes.
But I am reading from no teacher. No teacher posted in a school shall be made to serve in any other school. Thereafter, the expression or is used. Your lordship will find. In my humble reading, my lord, or is here disjunctive. Or office, again or used, or deployed. The expression or used before deployed again disjuncts the subsequent provision from the earlier provision. Or deployed, the two ors used in subsection 2 of section 25 would only serve disjunctive purposes. Deployed for any non-educational purpose other than those specified in section 27. The non-educational purpose, the exceptions have been carved out in section 27. So, my lord, it is not that is my humble understanding. This section 27 would only control the last portion of subsection 2 of section 25, starting from the word deployed for any non-educational purpose other than those specified in section 27. Time and again, your lordships have applied the principle of redendo singula singulis. My lord, this is a case where this principle has to be brought into play. One citation for your lordship's kind consideration. This is 2021 9 SCC 321. Considering the provisions contained in, my lord, the IBC, Insolvency and Bankruptcy Code. বলছি কি বললাম এক সেকেন্ডে 9 SCC 321 2021 9 SCC 321 kindly take paragraph 99 onwards.
Yes.
May I place, my lord?
Yes.
In addition to amending section 2, this was the Amendment Act of 2018. The same amendment also amended section 60 subsection 2. Interestingly, though personal guarantor was not defined and fell within the larger rubric of individual under the code, the adjudicating authority for insolvency process and liquidation of corporate persons, including corporate debtors and personal guarantors, was NCLT, even under the unamended code. The amendment of section 60 subsection 2 added a few concepts. This is best understood on a juxtaposition of the unamended and amended provisions. The unamended provision reads as follows. Then, my lord, I am not troubling your lordship with the unamended. Kindly take the amended provision. The amended section 60 subsection 2 reads as follows. Without prejudice to subsection 1 and notwithstanding anything to the contrary contained in this code, where a corporate insolvency resolution process or a liquidation proceeding of a corporate debtor is pending before a national law company law tribunal, an application relating to insolvency resolution or in liquidation or bankruptcy of a corporate guarantor or personal guarantor, as the case may be, of such corporate debtor shall be filed before the company law tribunal. The amendment inserted the expression or liquidation before the words or bankruptcy and also inserted the expression of a corporate guarantor, as the case may be, of such corporate debtor. The interpretation of this section has to be contextual. There is no question of liquidation of a personal guarantor, an individual. In such cases, This court has ruled that the principle behind the maxim of redendo singula singulis applies. This court had in Koteshwar Vittal Kamat versus K. Rangappa Baliga quoted Black's interpretation of law to explain the meaning of that maxim. Where a sentence in a statute contains several antecedents and several consequences, they are to be read distributively. That is to say, each phrase or expression is to be referred to its appropriate sub-object. Pausing here for a moment, my lord. The exceptions carved out to say in section 27 would only apply in case of the last portion of section 25 subsection 2 and not to the earlier portion, which are separated by two disjunctive expressions or used twice.
Yes.
Then, my lord, they referred to, my lord, Vittal, this Supreme Court judgment. Kindly take 101. Well, in Article 304B, bill, there is a provision that bill may be introduced and moved. Well, the expression is like introduced or moved. The amendment, bill introduced or amendment moved. When it's an bill, the introduction would, the word expression introduced would apply to bill and moved will apply to amendment. That is what the Honorable Supreme Court held in my lord Koteshwar's case. The next one would be, my lord, paragraph 101. Recently in Rajendra K. Bhutta versus MHADA, this principle of Koteshwar Vittal Kamat were cited and applied. Therefore, it is held that when section 60 subsection 2 alludes to insolvency resolution or bankruptcy or liquidation of three categories: corporate debtors, corporate guarantors, or to corporate guarantors to corporate debtors and personal guarantors to corporate debtors, they apply distributively. That insolvency resolution or liquidation processes apply to corporate debtors and their corporate guarantors, whereas insolvency resolution and bankruptcy processes apply to personal guarantors to corporate debtors who cannot be subjected to liquidation.
Yes.
So, my lord, to conclude, my lord, in my most respectful submission, he was some little comfort. That is one thing. Well, kindly take, well, what should I refer? I don't understand, because according to me, page 48 and 49 is not even a SOP. Well, let us take whatever is there. Even if the SOP, well, I use, well, this SOP is, well, I would use two expressions. Well, permit him for using. This SOP has the crown of three U's: unsigned, undated, unauthenticated. And it is also that page 48 to 49 is also a work in progress. Kindly take the work in progress one, page 48, na 49, 49. Well, kindly take clause F, modalities for transfer. Page 50 of our petition, na there. Oh, এইটা মানে এটা তো SOP নয়, তো কি বলছিস? যেটা দিয়েছে সেটা বল। Kindly take, my lord, clause F. If a surplus, I'm sorry, my lord, I should have waited.
Yes.
If a surplus teacher fails to submit preferences within the prescribed period, or if the preferred schools cannot accommodate the teacher due to limited vacancies, the competent authority shall assign the teacher to any identified high PTR school based on administrative exigencies and educational need. Such allocation shall be final and binding. So, my lord, ultimately, willingness is no willingness. It's not the question of being willing. It's a question that you have to be transferred. The option which I exercise, I may have exercised the option for X school, which may be 20 kilometers away from where I'm teaching. Then, my lord, the rule says so. This SOP or whatever this document is says that no, there is no accommodation in that school Y. You have to be accommodated in school A, which has, according to them, their perception, has less number of teachers. deficit staff, which may be 100 kilometers away. But I am not pleading personal inconvenience in this matter. I am only on the legality of the issue. Legality of this particular document. Well, I don't know what, but this document requires a new definition. My most respectful submission. So, Mala, these are my respectful submission. এটা সুবিধা বলে দিয়ে রিপিট করিস না জজ সাহেবকে unnecessary don't bother. My lord, I conclude, but I reserve my right to give reply. Your lordship will give me 20 minutes or 30 minutes to give reply. My lord, we are. But these are my respectful submissions.
Okay.
So grateful to your lordship.
Thank you. Mr. Ahmed. Where is Mr. Ahmed?
The interim order will have to be extended in the meantime.
Let us complete first.
Yes.
Mr. Ahmed. দেবনাথবাবু কোথাও বলুন দেবনাথবাবু কোথাও
My lord, may I just humbly submit, my lord? Mr. Ahmed is, my lord, is on his legs, my lord. My lord, the junior is at a loss. My lord, what I can request your lordship, my lord, obviously, if your lordship gives Mr. Ahmed 20 minutes time on the next day, that's it. 20 minutes বেশি পাবে না। Whatever, my lord, if your lordship, my lord, I leave it to your lordship, my lord, but your lordship will kindly give, my lord, he is on his legs.
We have still 15 minutes time. If he can conclude today, we can take up the hearing from the state.
Yes, yes.
How long? On Friday, then you will not conclude, then it goes to Monday.
Well, your lordship is keeping this matter on next on?
Either let Mr. Ahmed conclude, then I can say that state will argue on Friday.
Yes, my lord, your lordship will kindly, my lord, I believe, my lord, Mr. Ahmed is generally, my lord, he must be stuck up, my lord. Otherwise, he would have.
Where is Mr. Chaturvedi? We can take after Mr. Ahmed's complaint. We can continue with the hearing of the state.
Yes, my lord.
Mr. Banerjee,
He's on legs as well.
we can do that on Friday.
Yes.
Yes, we will.
That was the time to Ahmed to complete.
Let them, because what they are proposed to do, we are going to Friday.
Yes, on Friday, if he concludes by half an hour, then we can start with this. Yes,
will take over.
Start
then
with
my
the state.
government leader will start his submission, and then I will supplement my 2-3 points what I have.
Friday, Friday, they conclude that.
Please represent AGP. Junior Standing Council is there. So he will continue, and then I will required. I will.
11:30 পরে বলো।
Yeah, they will finish.
Friday কিছু নেই। করে দিন না, ওরা করে দেবে।
হ্যাঁ?
Or lordship can keep it on Friday. Let them complete Friday, and then we will come back on Saturday, Sunday. We will prepare. Monday we will give.
Yes.
My leader will first give the reply. Then my junior standing council will give the reply, and I will supplement both.
কি বলছো? Monday.
তাহলে তুমি 12টা 12:30 রাখো না, 12:30 দিলে হয়ে যাবে।
Let them complete Friday. So lordship.
Friday at 12:30.
Well, they will make some. I have concluded my submissions. Well, I think Mr. Dasgupta and Mr. Ahmed.
12:30, he is correct.
Yes.
That you conclude so that they can also make their submission.
They must have been held up, my lord. Otherwise, they would definitely be.
So after the complete, we need a 1 day, 2 days time to prepare ourselves, and then we will. The weekend we will be using.
In the meantime, my lord, the arrangement to continue. If you manage.
Yes.
Yes.
It will be till next Wednesday.
Yes.
So that on Monday you are coming back.
Yes.
On Friday they will complete. Monday you conclude that.
Monday they can, but I have some difficulty on Tuesday as well.
Till Wednesday.
Tuesday go.
Tuesday. So the interim order is extended till Thursday.
But till Monday week, my lord. Till Monday, your lordship will deliver a judgment of this.
What I'm on to is let them conclude. Till Thursday, the interim order will be there. On Tuesday, they will conclude.
As it pleases, as it
In the
pleases.
meantime, Wednesday is there. You can
Yes,
make your
yes, as
reply
it
by
pleases,
Thursday.
as
It will
it
be concluded.
pleases your lordship. My lord, we will.
Yes, we'll come back on Tuesday.
It will reply on Tuesday and 12:30 they are concluding on
Friday.
Just- And then Tuesday is also Lordship keeping it at 12:30.
That I check.
Yes, Lordship, 12:30, 2:30, whatever, so that we can keep.
But Mr. To be Sana Learned, senior advocate appearing for the petitioners in WPA 19893 of 2026, who concludes his argument. Mr. Vikas Ranjan Bhattacharya, Learned Senior Advocate, appearing for the petitioners in WPA 19417 of 2026, and Mr. Abrutos Mujumdar, Learned Senior Advocate, appearing for 99 WPA 19903 of 2026, also concludes their argument. Accommodation is sought for on behalf of Mr. Shamim Ahmed, Learned Advocate
And
in
Mr.
WPA, and Mr. Sudipto Dasgupta. Mr. Ahmed is in 19720, 19720, 19720, and
Sudipto konta hai?
19857 of 2026. Release this matter on Friday, that is 28 at 12:30. The
কালকে করে দাও না, কালকে ছুটি কি আছে? কালকে আমরা তো কালকে করে দাও।
কালকে ছুটি, কালকে করি, শুক্রবার ছুটি করে দিই।
এটা খারাপ না কিন্তু।
এই অর্ডারটা দাও না, ইন্টারিম অর্ডারটা, এটা
পারবে?
ওকে তো রাখিতে বেরোতেই দেওয়া উচিত না। বিয়েটা করতে পারিনি ওকে, এরকম 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 লয়ারকে রেখেছিস কেন তোরা? হ্যাঁ,
ওই জন্য জুনিয়র রেখেছিস, সিনিয়র ওটা করছে।
একটা বিয়ে থা করতে পারিস না, অপরাধ একটা। হ্যাঁ, বড় বড় কথা মুখে খালি। এবারে গিয়ে বলবো আমি না,
এত টাকা
और बाड़ी के देखे
Mr. Chatterjee, do you have any objection if it is taken up tomorrow?
tomorrow
Do you have?
you can get it.
the interim order
I do not have the objection.
granted earlier.
That's sectional holiday. I don't want that.
Friday
No, you can't have holiday tomorrow.
In terms of order dated, asked in terms of order dated
You want it tomorrow.
12th August 2026.
এই না 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 এখন তো স্বামী নামে
The interim order of consequent orders basing on such data, interim order basing on the data need not be passed till
স্বামী না ইমাম ও কমিউনিস্ট
Thursday টা কি তারিখ হচ্ছে দেখো,
তোমাকে পেলো কোথায়?
Thursday কি তারিখ হচ্ছে দেখো,
তোমাকে বিপ করতে আমি লোক ওরা তোমাকে বিপ করে না, আমাকে
third September. On Friday this will appear. Till 3rd September the interim order arrangement will come. Who is planning to come tomorrow?
Mr. Sanyal Mellon, he wants to come tomorrow.
I can come tomorrow.
Let Mr.
What will happen to Mr. Biswas?
তুমি করবে বলো।
Thank you.
আমার আর বলা আর বাকি নেই।
And Malak, my all adversaries are free to come tomorrow because they don't want this.
Don't. Okay. এটা Mr. Bose কে দিয়ে। Thank you.
Malak, 3 PM matters. Item number 308.
The other side is there?
708.
Other side is there?
Yes.
কি বলছো ওটা দেখো তো, দিব্যেন্দু চ্যাট করেছে। এই দেবনাথ বাবু, এইটা কে দিয়েছিল? এটা আমাদের না? ওই দেখবেন ওপরে না রিট পিটিশন নাম্বার দিয়ে আমি জাজমেন্টস গুলোকে আলাদা করে রেখেছি। প্রত্যেকটা রিট পিটিশনে জাজমেন্ট গুলোকে প্লেস করি, ঠিক আছে?
Extremely, my lord, sorry, from starting. Extremely.
So it will appear on Friday. Friday 12:30 you conclude because state will be giving the replies on Tuesday.
My lord,
Thank you.
extremely sorry, my
That's
lord.
all.
From 38, both of us were, my lord, in a match.
Okay. আমি বলে দেবো নেবে আমাকে দেখাবে এখন ওনার যে ম্যাটারটা আছে মিস্টার চ্যাটার্জির ম্যাটারটা দাও কত নাম্বার
Library heading টা
Okay, on a 3 p.m. which matter? Item number?
708. I am appealing for the petition in this matter.
You have received the money? Money you have
Yes,
received?
My lord, I am paying for not telling. Mr. Chaturvedi is appearing in this matter on behalf of the DPSC, my lord. He is engaging in another court, my lord.
Well, kindly see the orders. How many times they took action?
This is for disbursement of the benefits, no?
No. It
No,
was
no.
fixed at today 3 p.m. I mentioned the matter because my lord, my client, my lord,
Any day fixed, my lord.
he challenged the my lord, initiation of disciplinary proceedings as also the order of dismissal from the service, removal of service on the ground that there were procedural lapses in initiating the disciplinary proceeding. No inquiry report, no charge sheet, nothing has been given to him. Her.
So where is the finding of the disciplinary authority? Where is the finding? You have annexed?
No. What has happened? I annexed.
My lord, opposition filed, my lord.
They
I
have
filed the
annexed, but
opposition
nothing has
file,
been
my lord.
provided to the petitioner, my lord.
At the time of hearing, my lord, Mr. Chaturvedi
Yes,
will
that-
submit it, my lord. No, my lord. In presence of Mr. Chaturvedi, my lord.
You have given a reply.
Yes. But
Everything
ready
is
for
complete.
hearing.
Ready for any day fixed, my lord.
এর ডেট বলুন তো ফাঁকা দেখে বলুন Mr. Dibyendu Chatterjee, learned advocate for the petitioner, informs that the General Provident Fund amount has been received by his client. You have received?
Yes.
Okay. On the joint prayer of the parties, list this matter on পুজোর আগে ওকে দিন আমার নামটা start. How long you will take?
It will take half an hour for my side.
পুজোর আগে না হলে পুজোর পরে যাবে 24th তাই হোক মানে এসে গিয়ে কিছুটা ঢুকে যাবে 24th ঠিক আছে ওপর দিকে রাখো 24th
Actually,
24th September
time minor please.
টাইম লাগবে না 24th is which day কোন দিনে
24th September.
Thursday 24th is Thursday হিয়ারিং ম্যাটার ওপরই থাকবে টপের দিকে রেখো সেকেন্ড হাফে নেব দাদা এটা ঠিক আছে কি আছে দেখি যদি
library matters, my lord, only thing, it is not possible, my lord, these persons are suffering, your lordship only directed me to, my lord, renew my prayer, so it can be fixed any day and time, so that it is not a big matter, it will not take much time.
item number
66111.
451 to 661 to
661
673.
661.
51 to 673. My lord, the issue when Mr. Bandyopadhyay has been appointed amicus curiae whether
He's here, he's coming.
about vacancy of
Oh.
exempted category seats to be converted to unreserved, those vacancies to be applied to the same selection process or carried forward to
The next year.
This is the point involved.
What did I tell you on the last date that the pleadings are complete or not?
Pleadings, my lord, in some of the matters, pleadings we have given a reply, but state did not possess, my lord, the original affidavit. That also we have served the affidavit
In all the matters.
opposition to them, those in which they have been filed. We have served the advocates who gave their name that they are appearing in this and this matter. My lord, one government claim is appearing in one matter. We have submitted. In other matters also we have submitted. But my lord, we
চারটের সময় নিচ্ছি না চারটের সময় নিচ্ছি এটাকে সরাবেন এটা টপে থাক Mr. Dasgupta, let the matter retain in its position. In the next week we can take it up if possible. It will carry on. এটা থাকে এটা উপরই থাক